Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today. While we are waiting for the verdict in Monica Sementili, which we will be streaming a little bit later today, we are going to do some broadcasting of some other trials that are going on as well. We're going to do Kouri Richins, who had a pretrial hearing today on this week, April 7th, a couple days ago. And thank you for joining us. Appreciate you for joining us on this while we are waiting for Monica Sementili to start in about an hour. So, Willow Johnson, hello to you. Shirley Roth, Widespread Panic. Brett, how are you? Wendy Williams, how are you? Baka. Fala, good to see you. Hola. So good to see you guys. Thank you so much for joining us. And it's a Friday. How's your Friday going? For those who are watching live, it's Friday. For those on replay crew, thank you for joining us as well. Only fan, hello to you. Capri Law, good to see you. Lou, thank you for joining us. Jen 405, Cajun Butterfly, real happy. So good to see you. I'm sure Gigi's probably happy to be off today. I know Joe Schmo is happy to be off today. Let's see. Widespread Panic asks, are we planning to cover the Richens trial when it happens? We are. But some events happened that we'll talk about with this. Butterfly Dana, good morning to you. I have a surprise for everybody. Nan R, good morning to you. I'll let you guys come in a little bit. Carol, hello to you. We have a surprise for everybody. So real happy. Yes, real happy. Are you real happy? It's TGIF. Excuse me. Yes, I have a surprise. Friday surprise. The surprise is it's this little girl's birthday today. This little one's birthday. Emmy G, hello to you. So it's little Super Ball's birthday today. It's not a big surprise, but it's a surprise nonetheless. So, oh, come on. So we're not exactly sure when she was born, but Aaron first saw her, I think around, well, it was 6 years ago, and she was probably a week old, right? Because her eyes were still blue. So we backed it up and we figured today, April 11th, is her birthday. So I have a surprise for you guys. We just made this little thing. It's cute. Wait, hold on. Let me rewind it. Stop. Okay. So we just put together this little thing of Super Ball through the years. So check it out. It's cute. So that's it. She's 6 years old, Baka. The sink one should be her Tinder picture. I think, let's see. Let's watch it again. That one's a good one. I like the tongue. Meh. Upside down, meh. Up close, meh. Beans. That's her Tinder one. You think that's her Tinder picture? I like this one. Not that one. She does that so often where she'll clean her belly and she sits like that. Kitty yoga. I think that is just the most. She's like, what? I think we've posted that before. I like that one. I love that lighting. That one's really good. So we have to get her on Tinder now. Yep, the tongue. Majestic Super Bowl. She's flexing. Look how big her muscles are. She looks like she's like, we are here to pump you up. And then that one, I like that one. It's like, the Adam and God, the finger. I think that one's cute. So, all right. So that's our surprise. It's Super Bowl's birthday. She's sleeping over here comfortably. She's in the cat cloud over here. And so far for her birthday, she's gotten some tuna. We gave her some tuna this morning. Kitty Tinder, the Sunball ones. The Sunball ones. You love the last one. Super Bowl, yes. So happy birthday to Super Bowl. She got some tuna already. Not sure what else. She doesn't like catnip, so we'll try give her catnip again. But she's basically got some tuna, and because tuna is pretty rare, we don't give her. We give her tuna like a couple times a year. That's about it. So, but she got lots of love this morning. So, a cat cloud, I guess. I mean, we had so many great names for it, and I have them. What were some of the names? Let me go back. It was in the Monica trial. Let's see. We had some great names. You guys came up with some great names for this. What therapist sent to us? Hold on, where's Monica? Is it here? Closings? Yeah, let me see. So some of the names were Catnapper, the Super Bowl Sling, Super Bowl Sloucher, Super Bowl Cloud. So maybe that's what I was saying, the cat cloud. Super Bowl Sidecar, Super Bowl Glove, Kitty Cat Chaise, Super Bowl Snuggler, Catamaran, that's a good one, Super Bowl Soft Sit, Super Bowl Sanctuary. Yeah, it just seems easier just to say the cat cloud. Hey, Irish Amy, how are you? Thank you for ET phone home. Yeah, that's a good one, Baca. I like that. Kit Tinder. Your kitties and doggos both love tuna, and I treat them at least once a month. Yeah, that's nice. Wendy. And Pammy, damn, I want to be Super Bowl. Pammy Sammy. Sammy, we were looking for you earlier. Yes, my sidekick, Carol. She is. So, therapist, got us this little cat cloud, cat sidecar. Yes. Cow Junkies United, how are you? Thank you for joining us. Lily Wayne, yeah, she has not partied yet. All right. Okay, so we are going to get to Pammy Sammy. Thanks for the hobble hugs. All right, we're going to cover Kouri Richins. Get myself set up here. All right, so this was April 7th. And Kouri, for those that are not familiar with Kouri, she's 34. Well, she was 34. She may be 35 by now because I wrote this back last year. This thing's been going on for a long time. So she's accused of deleting her husband, Eric, right? And he was 39. So this happened on March 3rd of 2022. And the state is alleging that she laced his drink with fentanyl. So people were saying it was a Moscow Mule, but he would have tasted it. Some people are saying it was a lemon shot or a lemon drop shot, limoncello, whatever. So if you're drinking a mixed drink and you're drinking it slowly, you're gonna taste the fentanyl. So now I think the latest theory is that it was like a shot, right? So his body was found at the foot of their bed, and this was on March 4th, right? So a year later, she wrote a book. Right. And they have 3 kids. And the book was Are You With Me? And it was basically supposed to help the children cope with the grief of the loss of their father. Right. So she was arrested in May of 2023, and she's charged with aggravated drug charges, mortgage insurance fraud, and she's being held without bail. So that's kind of the backstory with Kouri. She's been in many pretrials. We've covered a couple of them. And then this is the latest one. And the judge is Mrazik. You guys know his voice. Yes, this is the judge, Amy. This is the judge. There he is, Judge Daddy, or whatever you guys want to call him. But he's got the voice of a baritone. Hey, Anja, I didn't get my notification. Aw. Oh, cool. I'm glad. Hey, you guys, I don't know if you guys are on any social media, but we're on Twitter and we're on Facebook and we're on Blue Sky, right? So if you ever are wondering, you can always come to our page on YouTube, our channel, to see what we're posting. But if you can't for whatever reason, and if you're on any of those other platforms, we're always saying what's coming up. So I know a lot of people don't want to go to Twitter or Facebook. I get it. But if you want to keep up with us, you can either just go to our channel, because we're pretty much streaming every day except Saturday and Sunday, and sometimes we are doing that as well. It's a very, 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 very rare day that we will not stream on a Monday, Tuesday, Wednesday, Thursday, or Friday. So chances are we will be streaming. So we're always check those platforms if you can, and if not, just go to our channel and you'll see us. So Discord gives notifications too. Okay, cool. Thank you, Ola. Hey, Gordon, are you with us? There you are. So many women bumping their husbands off. I know, right? This is the year of the woman defendant, right? We've got Monica, we've got Lori, we've got Kouri, we've got Karen, although that wasn't a husband. We've got Donna, and that wasn't a husband, but a son-in-law, right? That's 5. The only one I can think of huge is Kohlberger. He's like the only male. Like, it's like 5 huge trials that have women. It's crazy, right? And they're like one right after another, or they're happening simultaneously. What's going to happen in like September, August, September, October, when all these trials are done? So, all right. Gordon sounds scared. No, Gordon, are you scared? Are you scared, Gordon? I don't think you're scared. He's got the voice of an angel. Yeah, he's got the Barry White voice. He definitely has the Barry White voice. All right, enough of my preamble. Let's get to Judge Daddy. So this is Kouri is asking for a change of venue, right? So this is basically what this is about.
We're on the record in 213-500-139, State of Utah versus Kouri Richins. Can I have counsel for the state make their appearance, please?
Good morning, Your Honor. Brad Bloodworth and Lindsay Sherbanak for the state.
And on behalf of Ms. Richins.
Wendy Lewis, Catherine Nestor, and Alexander Ramos for Ms. Richins, who is present.
Very good. Good morning, Ms. Richins. We're here this morning on a motion for change of venue filed by the defendant. I've spent a lot of time reading published cases regarding motions to change venue. I've spent a lot of time looking at the defendant's and the state's survey results. I have several questions. Ms. Lewis, are you arguing the motion?
Yes, Your Honor, but I have Dr. Edelman here, and I'd really like to start with his testimony, and then, yes, I will be.
Let me ask you a question about that. If I assume that Dr. Edelman's survey results are sufficiently reliable to be admissible, I have a couple of clarifying questions about what questions he asked and what the range of responses were. Does he need to testify to anything else?
Yes, Your Honor, he does. I think he needs to testify about the methodology used by the state and why that survey is not reliable.
This is why I'm confused. Doesn't that survey weigh in the favor of your position?
Yes and no. I mean, the bottom line of the survey in terms of the number of people who are aware of the case is similar. But the state survey does not deal with the ultimate question regarding guilt or the perception of guilt in the community, which is really the point of a change of venue survey. And which Dr. Edelman can explain so much better than I can, but in terms of looking at the ultimate question of guilt and in terms of looking at what specific facts that are in the media that potential jurors are aware of, the state survey does not identify any of that.
Okay.
And the way the state survey is conducted is not within the methodology that is typically used for change of venue surveys. It's a different kind of survey. And Dr. Edelman, I think, though, can fully explain the results of the survey in detail that we have presented. He can answer your questions. He's got a PowerPoint presentation that goes through how this works and how it should be considered, these surveys, in a change of venue.
All right, that's fine. All right. I may move that examination along to the issues that I think are most relevant, but that's fine.
Okay. Are we ready?
Mr. Bloodworth?
Your Honor, before that, the state has a motion that may impact this testimony.
Sure.
May I?
Yeah.
Your Honor, on December the 17th, 2024, the parties sought extraordinary relief from the Supreme Court, in part in connection with their compromise regarding jury selection. During the pendency of that interlocutory appeal, the defense informed the court that if the Supreme Court rejected the parties' compromise position, then the defense would file a change of venue motion.
I'm sorry, Brad. I can't hear you very well. Can you? I apologize.
The Supreme Court issued its order that rejected the compromise on February the 18th, 2025. Rule 29 gives the defense 14 days from that date to file a change of venue motion. The defense did not file its change of venue motion within the rule's time period, but ultimately the court ordered that the defense file its change of venue motion on March the 17th. Presumably
Hold on. Who ordered them to do that?
Your Honor, you did.
I remember saying something along the lines of, you keep mentioning a change of venue, but you keep not filing it. So I set a deadline by which we had to get this thing briefed.
Correct, and that deadline was for the opening brief from defense was March 17th.
Okay. Understood. Keep going.
Presumably because of the time crunch that the defense's delay caused the court order that the defense would not get a reply brief. Yesterday evening, a Sunday, the defense filed a 16-page expert affidavit styled as a supplement to its change of venue motion that is found at docket 970. In reality, that affidavit is a poorly disguised reply brief. The state has not had sufficient opportunity to meaningfully review it, much less cooperatively consult with the defense's expert or discuss the affidavit with the state's expert. Accordingly, the state moves to strike that affidavit from the record.
The state's motion is denied. You can is denied without prejudice. You can reassert it if you determine it's necessary, depending on whether I ever rely on that affidavit at all during this hearing. I have some concern that you're all missing the point. Why couldn't the court just accept both surveys and say they show a range and engage with the numbers in each survey?
Your Honor, the state prefers that the court proceed that way. I've seen the draft of the 100 slides that Dr. Edelman's fixing to testify to. I would prefer the court just ruled on the papers.
I mean, I do have some questions for Dr. Edelman about whether I'm understanding the other side of the numbers in his surveys correctly. So I'd like to hear from him to make sure I get some clarification on that. And if it turns out that I'm misunderstanding what the other 20.2% of the people that answered the survey said or didn't say, we may need to get deeper into it. But
I was just saying, I think it's important that we make a complete and clear record on this issue. As you know, this issue is highly important to the defense.
Understood.
And we want a complete record on this particular issue.
The hard drive that you submitted, does it make less than a complete record?
The hard drive?
Didn't they submit? Yeah. Isn't that thumb drive showing Dr. Edelman's complete survey and results and methodology in writing?
I think without the explanation, no, it does not, because someone who doesn't understand how these surveys work, it doesn't mean a lot. There's a lot of explanation behind how the survey was conducted, what those numbers mean, and how those have been applied to the reasonable likelihood standard in other cases, and how it should be applied in this case.
Wait a minute. He didn't disclose any of those opinions. Or why would I accept his opinions about whether there's a reasonable likelihood here? That's my determination.
No, he's not giving his opinion on that. He's explaining the standard and how it's been applied in other cases. He's not giving an opinion as to how it should be
Other
applied
Utah
here.
cases?
No, but the law is the same. The reasonable likelihood standard is the same, whether it's in Utah or not. That's the standard for a motion to change venue.
With respect, I'm not sure that's true. In federal court, the standard is much more. The reason, I think, candidly, that federal courts are upheld frequently with respect to denying motions to change venue is that the federal standard is very different. Here, I think it's in state court, looking at state cases, it's a lower standard, less than preponderance, the 4 James factors. I really care less about how we performed the survey versus what the results are. I'm persuaded that the methodology is sufficiently reliable to be admissible under Utah's threshold for reliability. I do have some questions, though, about what the results mean. Can we start with that?
Yes.
Okay.
We can start with that.
Dr. Edelman, may we swear you in, sir?
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Please have a seat.
Ms. Lewis, may I just start with some questions that are written in bold type on my notes, and then you can fill in and make whatever record you think is appropriate.
Of course.
Doctor, good morning.
Good morning.
Okay. I understand that let's stay focused on Summit County for the moment. How many people responded to the telephone survey?
What do you mean by responding? Completed it?
Yes.
400.
Okay, so when we look at results saying they or someone they know has a connection to the Richens family, 26%, that's 26% of 400 responses?
No, it's 26% of those who have read, seen, or heard about the case.
Okay.
So, yeah, so if somebody doesn't know about the case, and that's a fair point, they might know the family, that's true, but the skip pattern didn't do that. So,
Okay.
Yeah.
So maybe the better starting point is recognize the case. Is that correct?
Yeah.
Is that the first level?
Read, seen, or heard about the case, yes.
And use that phrase for me again.
Read, seen, or heard about the case.
Thank you. And so the 79.8% of respondents indicated that they had read, seen, or heard about the case, and that was based upon the summary provided in the survey, correct?
Correct. So there's those 2 recognition questions, which were built off of the media coverage. So read all the newspaper coverage, watched all the coverage, and then identified the things that were most salient and most likely to trigger a memory without being overly biased.
And I recall, and I didn't copy and paste it into my notes, that the brief summary of the case that was used to provide context for whether someone had read, seen, or heard about the case was Eric Richens died on this date.
Yes.
Kouri Richins wrote a children's book and is alleged to have murdered her husband. Is that fairly stated?
Yeah, so there's no reference to poisoning or
Right.
any of that kind of stuff.
Okay. So if 79.8% indicated that they read, seen, or heard about the case, does that mean that 20.2% of the 400 that completed the survey indicated they had not read, seen, or heard about the case?
Correct.
Okay. Okay. Then we go another layer deeper, and there's a question about whether, of that 79.8% that had read, seen, or heard about the case, am I correct that your survey results show that of that group, 69.1% had formed a belief that the defendant is guilty?
Correct.
Okay.
You notice it says prejudgment 1 and prejudgment 2. So prejudgment 1 is exactly what you just said, and then prejudgment 2 would be for the sample as a whole, for the population.
Explain prejudgment 2 for me.
So 70% believe she's guilty of those who recognize the case. But what does that mean if 100 jurors walked into the room?
Right.
Right. So, and that's that prejudgment 2. So I don't have it in front of me, but whatever that number is would be the prejudgment rate in the community as a whole. So that includes people who know about the case and don't know about the case.
And tell me why you can draw any conclusion about the prejudgment rate among those that know nothing about the case.
What do you mean by any conclusion?
Well, if they don't know anything about the case, why would they have a prejudgment walking in?
Yeah, and they don't. So it's only related to that know about the case. I don't think people who don't know about the case I would presume they don't think she's guilty because they don't know anything about it.
Okay, I appreciate that. So if we stay within the subgroup, the approximately 80% that have read, seen, or heard about the case, and we acknowledge that approximately 69 or 70% had formed an opinion that she is guilty, does it follow that 30% or 30.9, is it presume her innocent or have no opinion combined? Is that how it is?
Yes, but the presumed innocent is very low. It's like 1 or 2%.
Okay.
Yeah.
So practically speaking, it's have no opinion.
Yes.
Okay. Okay. And then if we go another layer, not deeper, but just another layer, of the 79.8%, there is 50% who indicated that the defendant would have a difficult time convincing me that she is not guilty. Is that 50% of the 79.8 or 50%? I think it's 50% of the 69, correct?
It is. Yes.
Okay.
And those rates change based on, like, if you know particularly prejudicial details, they go higher. So
Understood. Okay.
If you close
And would you, let me ask you this way, is a sample of 400 sufficient to show statistical significance?
It's the generally accepted sample size for these, so it's plus or minus 5% margin of error.
So that's 2 standard deviations from the mean. All right. And that would say that it would tend to scale to the population as a whole of the county?
Yes, and a lot of that question kind of goes down to methodology too, right? All the things you do, like it's a random digit dial telephone survey. We do callbacks. We do like soft refusal conversions. So people who kind of are on the fence about taking the survey, the interviewers are trained to encourage them to take it. We call at night. We call in the morning. We call on weekdays and weekends. There's an introduction to encourage them to take the survey. They're told there's no right or wrong answers. They can always say no opinion, don't know. They can call back if they have questions. So all of these things to try to improve response rates, so you're not systematically missing an important group of people.
Let me spring some questions on you
Yeah.
that I don't know that you handled in your reporter affidavit. Assume for me that 1,100 people who are qualified as Summit County jurors have filled out a 20-some-odd page case-specific questionnaire. I have no idea what it says. I just know there's 1,100 of them.
Yeah.
Is it a reasonable application of your survey data to expect that 20% of those 1,100 have not read, seen, or heard about the case?
Well, the survey was finished, I'm trying to remember the date now, in early March.
Okay.
So those numbers could change based on, I know, for example, I ran across a 45-minute interview on Court TV with the family's attorney representative,
Spokesman.
saying many prejudicial things. So those
Sure.
numbers could be higher.
Understood.
And it depends on how the questions are phrased in the questionnaire. Right? They're not. It just depends. I haven't seen the questionnaire, so I don't
Right.
know what it looks like.
Well, and forget about what the questionnaire says, but when they sat down to take it,
Yes.
is it reasonable, when they sat down to complete it, is it reasonable to expect that 20% of those people at that moment had not read, seen, or heard about the case?
Yes, I would say that.
Okay. Is it reasonable to expect that of those 1,100 people that had, of the 80% of those 1,100 that had read, seen, or heard about the case, 30% of them had not formed an opinion before they took the questionnaire as to the defendant's guilt?
Of those who've read, seen, or heard about it?
Yeah.
Yeah, that's
Okay.
what I would say. So, yes. That kind of comes back to my, if 100 jurors walked in the room,
Right.
how many of them would have already prejudged the defendant as guilty?
Okay. All right, I think I understand.
May I just add one thing? So, from my perspective, I always caution, because when we go down this route, it turns into a numbers game. Now, and I don't think, from my experience, I've done a lot of these, I don't think the question is, can you find 12 people who will say they can be fair and impartial? You can always find 12 people that can do that. And the biggest example would be if it was a numbers game, let's say LA County, 10 million people. Remember the Rodney King beating? Well, that was the Powell decision. So everybody in LA County knew about the case, but let's say 90% believed the officers were guilty. Well, that still leaves 100,000 people somewhere. And if it was a numbers game, you would never have a change of venue, because there's always some group of people in there that can, that don't know about the case. And that's not really the question about whether you can get a fair trial. And the other question is, what are those people who are left? So in a case like this, burden of proof might be very important, and you want really smart jurors that really understand beyond a reasonable doubt and are very inductive, analytical jurors. Those are the best jurors in this case. But they're also the jurors most likely to know about this case, because they're most likely to follow what's going on in their community. So your best jurors are the ones that are most likely to be excluded because they've heard about it, have developed opinions. And the question is, well, who's left? And that is not necessarily, ideally, a fair trial, in my mind. So I don't get into the numbers game where it's always, can you find 12 people? I mean, I've done enough jury selections. I'm sure you've done many, and you know what it's like when you're trying to, someone says they have an opinion. It's very easy to get them to say they can be fair and impartial. We do it all the time. It's an adversarial system. So I don't think at this point, that's not the question. The question is there a reasonable likelihood that she can't get a fair trial? So I focus on, is there a whole lot of bias out there? Do people know a whole bunch of detail? Do they know prejudicial detail? And the other problem is voir dire is, and the way memory works, it's very hard for people to recall everything they know. So if I say, tell me everything you know about this case or a movie, let's say Star Wars, I bet you all can tell me a bunch of good stuff, but you'll miss a whole bunch of important things. And if I asked recognition follow-up questions, you say, oh yeah, of course I knew Darth Vader was Luke Skywalker's father, right? In voir dire, you can't do that. You can't say, oh, well, have you read, seen, or heard if she confessed? Not true. She didn't. I'm not saying that happened, but if they don't mention a confession, that happens in a lot of cases. You'd be poisoning that juror. Maybe they know it, maybe they don't. For example, in this case, only 10% of the people mentioned the walk the dog letter when asked, what have you read, seen, or heard about this case? But later, over 40% recognized that item. So there's this group of people out there that know it. It's prejudicial. Maybe it comes into evidence, maybe it doesn't. Let's say it doesn't. How do you identify who those people are?
Those people that were asked about the walk the dog letter, was it only the group that had read, seen, or heard about the case that were asked that, or was it everybody?
We don't ask, if they don't know about the case, we don't then feed them information about it.
I understand.
So that's the biggest thing. And it's not just like conjecture. I mean, so this whole thing for me came about, there was a case in Texas, John Fight, and he was a Catholic priest charged with murder. He killed a beauty queen in like the 1950s. And this case had gone to trial for 30 plus years, and then they charged him with murder, brought him back, and all this. And in Texas, you actually have to bring people in the community, and they testify in the change of venue hearing about what they know and all these things. And we kind of treated it like a mock voir dire to prove that point. So they told us everything they knew, and we'd ask, well, is that everything you know? And they said, yeah, that's it. And we'd say, well, have you read, seen, or heard of John Fight confessed to a priest in a monastery? Oh, yeah, I knew that. But you didn't just mention. Sorry. Too much coffee. I'm sorry. I'll slow down. And it triggered a memory. And then we'd say, do you know anything else? They'd say, no. And then we'd say, well, did you hear that John Fight allegedly attacked another woman at a different church? Oh, yeah, I knew that too. It was in Edinburgh. Okay, is that everything you know? Yeah, that's it. And then it's, well, have you read, seen, or heard if there was a cover-up? Oh, yeah, the Catholic Church moved him around and blah, blah, blah. So that is the problem in these cases. In normal voir dire, none of that's an issue because people don't have case-specific attitudes towards a case. They just have general attitudes.
I appreciate your pushback to the idea that it's a numbers game, but I don't have an infinite number of options here. The defendant has asked me to move the case in one way or another to Salt Lake County jurors. Those folks are not blind to the media coverage of this case. If I understand your survey results, about 42.5% of them have read, seen, or heard about the case.
Yes.
And 57% of those folks have formed an opinion regarding that she's guilty.
Right.
Why don't all of the dynamics that you've just described apply with equal force in Salt Lake County?
Well, good question. And I think, one, it's far fewer, but also, more importantly, they are not as familiar with case-specific details. So the people in Salt Lake
But didn't you, and this is a genuine question, I'm not trying to cross-examine you, didn't you just tell me that people are not good about recalling what they know?
Well, let me clarify. When I ask, have you read, seen, or heard if, those are
Yeah.
recognition questions. And that's where we identify the extent of their case knowledge, compare it to the open. And they know much fewer case-specific details when we ask the closed-ended question, which memory's much better. They also reported that they didn't follow the cases closely, so they're not as engaged. They don't have as many connections. So there's a lot of those factors that come in. And it's also a much larger community, so as you'd expect, there's so much more going on in Salt Lake that this case hasn't captured their attention. I also look at the fact it's not very far away. It's not a huge inconvenience compared to some other cases, like in Moscow, Idaho, the change of venue moved it to Boise. Well, that's a big, that's really far.
Right.
And there, I'll give you an example, the recognition rate in Latah County was 98%, and was about 97% or something like that in Ada County. Virtually no difference there. The differences that mattered were the connections, the personal connections. Did they go to the university? Had they been to the victim's house? Had they seen it? It's those things. And you see a lot of those unique factors here. And that's kind of the stuff that stood out to me as justification. And just looking, again, at the severity of the crime and the fact that she's looking at, if convicted, many years in prison, it seems like a fairly reasonable, low inconvenience to move it to the largest county, since it's so close, and recognition's lower, prejudgment's lower, case-specific knowledge is lower, recognition of prejudicial details that really stood out are lower. So there's all that benefit.
Okay. Let me pause there.
Yeah,
Ms. Lewis,
that's a lot.
why don't you lay whatever other foundation? I appreciate you letting me get answers to my questions.
Oh, thank you. They're excellent questions.
All right. Can I just have a moment to sort of turn around my plan here?
Sure.
So, can I just hold this on to Dr.
Sure.
Yeah,
Skip over the stuff.
I thought we just went over a lot of what's in there.
Okay, all right. So, if that's right, Your Honor, I think we still pull up the PowerPoint. We can skip over a lot of it based on the questions you just asked.
Okay.
You just answered.
Sure.
And address what we have not done.
Brisky, would you turn that television on?
Do you want me to go through his background? I was planning on just...
No.
You're okay with...
I know how to read.
All right. Well, then why don't we just go ahead and start with that?
1 second, let me get, Alex, is there a PowerPoint that you want published?
There is one up, Judge.
Okay, 1 second. Let me do a little finagling here.
While he's pulling that up, Dr. Edelman, maybe we could just start with, when you were initially hired to do a survey on a change of venue, you said that you follow a three-part process, correct?
Yes.
And maybe let's start with explaining how that three-part process, what it is.
Yeah, so it's a three-phase process that was taught to me by Dr. Ed Bronson, who is one of the kind of forefathers of all this. He did like the Oklahoma City bombing case and Boston Marathon and Skilling and many of the big ones. And basically the first phase is to collect the media coverage and make an assessment if it contains any prejudicial, sensational content, the extent of the coverage, anything unique. If not, that's the end of it. So we don't do any more, and that's capped. So that's capped at like 6 hours. If it looks like there's extensive coverage or prejudicial coverage or something that might be concerning, like maybe there's one specific item that stands out, like there was a trial, somebody was convicted, and then the conviction was thrown out years later. Well, that's pretty prejudicial to know that a jury already convicted them. That might justify going to phase 2, which would be a community attitude survey to assess the impact of the media coverage on prospective jurors. Because just because there's prejudicial coverage doesn't mean it automatically has an effect on people. I've had cases where we've done the survey where there's a lot of coverage and there's low recognition rate or not a high guilt rate. Once the survey is completed, there's a range of things that the data may support. Could be not a moderate issue where recognition is like 40-50% and guilt's not very high. It's a big community, so maybe it's just like extended voir dire, a better questionnaire or individual sequestered voir dire, a lighter cause challenge standard, things like that. All the way down to, like in federal, there's a lot of intra-district transfers we do within the district to state cases, change of venue. So it just depends. And then the last phase would be what we're doing now. If both sides don't agree, we would get here. And sometimes they do. I just did one in Tennessee, the Tyree Nichols case, and both parties agreed to move it. So we didn't have a change of venue hearing. The judge moved it based on the survey data. So those are the three phases. So it's not just like, let's go spend a bunch of money on a survey. It's let's do it piece by piece so you're not burning through county money. That's the ideal.
Let's just go ahead. All right. Why don't you just go ahead and, Judge, if you want us to move on something, that just why don't you let us know?
I think we can keep moving. I'm really more concerned about the results of the survey here and any nuances in it that you fear that I wouldn't appreciate by just reading the summary of the data.
Sure. Well, I will say, just on this issue, we don't have to go through all this, but you can, if you want to skip to the media coverage itself and not so much. This is kind of the impact of pretrial publicity and how it works, the cognitive process on juror decision making. But do you want me to walk through this? Or?
I don't know if right now if this would be a good time to address how the pretrial publicity can be confused with evidence in the case. When we have a jury who has been exposed to a lot of pretrial publicity, how can that affect them when they're sitting as jurors in the case?
Yes, so there is research on that and how memory works, and there's one study, what they did was they read pretrial publicity and then 5 days later watched a murder trial, and then a couple days later they were asked whether the specific pieces of content were from the pretrial publicity or from the evidence they heard, and after just a few days, the source gets stripped, it's integrated into a general memory, and you can't remember if that was pretrial publicity, if it was trial evidence, or it was in both. And that's just how memory works. Like,
Dr. Edelman,
yes.
May I cut to the chase here a little bit? That would seem to counsel in favor of never impaneling a potential juror who had been exposed to pretrial publicity at all. That, I don't think, is the law in any jurisdiction in the United States. How would you say, what's the through line there about the fact, especially in the modern media environment?
well, I think the significance of that, again, like people's exposures on a spectrum. So if someone just said, well, they know very little, I'd be less worried about it. If someone knew, for example, about a prior conviction, those are things that become significant. So if you can't remember if the prior conviction came into evidence or not, those are bigger things. So I don't think it's for everything, like you said. I think if you look at the types of pretrial publicity that are most impactful or what your biggest concerns are. This case had some things that were initially reported that maybe are not true, or maybe those theories have changed. So but you've already been exposed to it so much. One of the most common things is that you saw was that she was poisoned with a Moscow Mule, and people spontaneously mention that. There's a big belief that's true, and if the theory has changed, well, that's very significant in this community in terms of people believing that. So you're starting from the point you already assume that's correct, and so if they hear something similar, for example, oh, it was a different drink or whatever, you're just triggering a memory. So you're not hearing evidence for the first time. It's not like, oh, I'm looking at the probative value of this new evidence as a blank slate. I'm just recalling what I already know and integrating consistent information with what I've already read, seen, or heard.
Is the, see if I can summarize this correctly in my question, is the percentage of respondents who identify familiarity with some of the more inflammatory facts of the case higher among the group who indicated that defendant would have a difficult time convincing me that she is not guilty, or is there not that correlation?
There is.
Okay.
There is. So that's correlated with the number of details they know, which is consistent with the social science literature. That's an internal validity check. You see that relationship. It's consistent with how closely they followed the case, how many details they know, and specific details that are more prejudicial than others.
And on the flip side, if they indicated that starting small, going larger in terms of group size, they have formed an opinion that defendant is guilty, but defendant would not have a difficult time convincing them that she's not guilty, or they have read, seen, or heard about the case and have formed no opinion regarding defendant's guilt. Do your survey results show that those groups of people, those subgroups, have less case-specific detail recollection, less exposure to pretrial publicity?
Yes. So it's when we say less, it doesn't mean it's not high. It depends. You have to look at it. And there's actually we have a chart on exactly what you're asking.
Can we go there?
Yeah. That would be the only thing I'll say on the coverage. If you jump into the one slide, I just wanted to highlight was keep going. We can skip all these. This is just it was with keep going. It was one more. No, just because there's one that was, this is what most concerned me. I just want to touch on this before we move on. So one of the things is the imbalance of the coverage, where you have information that's supporting one side and not the other. So when you have Mr. Skordas going on TV and espousing, not only repeating things, but speculating on motive and the psychology of the defendant. In this episode, this is a 45-minute long episode that appeared just a few days ago, and there's stuff in here about not only about the boyfriend, but about this woman is speculating on the defendant's mental state and so on, without ever evaluating her, and then Mr. Skordas is supporting it and reinforcing it. So it's not like this stuff has stopped. It's still happening. It's very prejudicial. It's only on one side. And that is one of my bigger concerns, is all this pretrial publicity benefits one side. It's not balanced, and one side's not speaking to the media, and the other has free rein to do stuff like this. So that's quite concerning. So I just want to highlight that before we move into this survey. I think it puts the defendant at an unfair advantage, and it helps the state quite a bit.
All right.
We just acknowledge for the record that Mr. Skordas is a spokesperson for members of the Richens family, not for the state of Utah.
Yes.
Yes.
Okay.
But it still helps them.
No, I
get the benefit of it.
I understand.
No. Okay.
All right, go ahead, Alex. And Dr. Adam, why don't you just stop us when you...
Okay. We're at the survey now.
All right.
So if you want to, would you like to skip just to those tables, or?
I mean, I understand what makes a juror eligible in Summit County. We can keep rolling here.
Right. This is just the structure of it.
Okay.
So these are the high level, and most of these surveys are designed based off of 30 plus years of research and people doing these. So there's very clear standards of how you do a community attitude survey for change of venue. And a lot of those questions have been tested, validated. We do cognitive interviews before the survey goes out, where we read the survey question to people and ask them to interpret the question verbally so we understand, to make sure they're processing it correctly and understand the answers, so that people answer the question and interpret it consistently, which goes to construct validity, so important. But yes, so this kind of just shows a high-level recognition rate, 80 versus 43%. You can see half of those who know the case followed it somewhat or very closely. In contrast, Salt Lake was just 25%. You have a guilt rate of 69% versus 58. Definitely guilty, 18 versus 8. And that my surrogate for fixed opinion, the presumption of guilt instead of presumption of innocent, is 50%. And then negative opinions. You can see people who've been exposed to the media coverage have somewhat or very negative opinions of the defendant.
Let me ask you on the question that, would you have a difficult time convincing them? Would Ms. Richens have a difficult time convincing them she's not guilty? Mm-hmm. Where did that question come from? You said that's the question you use to talk about burden of proof, really, but how did that question, where was it devised from?
Yeah.
And
so one of the more controversial questions is, can you set that aside and be a fair, impartial juror? And there's a bunch of research and literature on it that it creates socially desirable responses, and you'll see inconsistencies. So people will say, 74% will say they could be a fair and impartial juror, like on remember the American Taliban, John Walker Lind case?
you're really fast.
Sorry. American Taliban case. 74% said they could be fair and impartial, and that he deserved a fair trial, and so on. But 30 plus, I think it was 34%, gave inconsistent answers in the survey. Like, he's as bad as Osama bin Laden. He's definitely associated with the Taliban. He's definitely guilty. So you're not seeing consistent responses. When we look at what's called internal validity, you want consistent relationships. So if somebody thinks someone's guilty, strongly believes that, they should say they cannot be fair and impartial at much higher rates than people that don't know anything about a case. And you don't find that. And it's because there's a clear, socially desirable response. I'm supposed to be fair. I want to be fair. I want to be a good citizen. And people don't know how evidence is going to impact them because they don't know what's going to happen. This question was...
Dr. Edelman, maybe ask you a question. What order are the questions asked in? What do they ask the fair and impartial question first, and then the other more specific questions regarding...
In which study?
The American Taliban case.
In the American Taliban case, it was after they are asked the guilt question, they're asked the fair and impartial question, and then later on in the survey, they're asked different questions.
Why aren't the questions asked in the reverse order? And are there surveys in which they're asked in the reverse order and internal validity goes up?
I would have to look at the exact instrument, because it's probably 40 pages long. But unfortunately, I don't have that in front of me, so I'm not sure. I could say I've done research on this question with I don't know if you remember the Robert Durst case. Yes, the Jinx. So what we did was we recruited people from the Jinx Facebook page who publicly stated very sensational, inflammatory comments, like, he's a sociopath. I'm so glad he was arrested. I'm physically ill. These are pretty strong statements. If a juror said that in a courtroom, they'd be excused for cause, even if they say they could be fair. And then in the survey, we asked what they knew. They knew about the confession. Remember, the Jinx, you have the microphone on. They knew about murders that were inadmissible in the new case. They reported that he's guilty. I think it was like 100% or something like that. And a very high rate said that he couldn't change their mind, the question we asked. Then we read them a standard instruction from a real case about the law requires you to be fair and impartial. Everybody deserves a fair trial. And then we ask them the follow-up, can you be fair and impartial and set it aside, and why? And all those jurors or people who professed extraordinarily strong opinions in a public forum magically say, oh, yep, I could be fair and impartial. And the woman who said, he's a sociopath and physically ill, was, I can listen to the evidence, everybody deserves a fair trial. So there's just no underlying support for the notion that that is a reliable question. There's also published literature on it. I'm not going to go through all of it, but one study, Moran and Cutler, over 70% said they could be fair and impartial, but 34% said that they couldn't put the media out of their mind. Inconsistent. This question came from a judge in Tennessee in a murder trial, Nicholas Johnson, and all of these jurors had a lot of detail, and the judge would ask them the magic question, can you be fair and impartial? And they would kind of, I think I can try, things we've all seen a lot. And then he'd say, he asked them this question, well, would Nicholas Johnson have a difficult time convincing you that he's not guilty? And they'd say, oh, no, he can't change my mind. So it was like this clear epiphany. So when I saw that, I was working on the post-conviction stuff. I started using it in surveys and found that it's consistent, it's internally reliable, it correlates with things like case knowledge, how closely they follow the case, prejudicial items. So it has all those checks that you want to look for internal reliability and validity. So I started using it.
Okay.
Okay. And this kind of is an indicator of the difference when we talk about connection and impact. This is a relatively small community, and you can see 70% have talked about this case or heard people talking about it online versus just 25% in Salt Lake. And those are some of the things that really stand out when it comes to spreading rumors, misinformation, demonstrating that this case has captured the community's attention, is just people talking about it. And seeing it on social media, and then the connections to the family.
Will you go back one slide, please? Okay.
Okay, so this comes back to case knowledge, or media items knowledge. I shouldn't call it case knowledge. But you can see that people in Summit County who have heard about the case recognize quite a few details that were widely reported in the media. So 60% of them knew at least 4 of the 8 items we tested, and 56% knew 5 or more. And you can see those numbers are much lower in Salt Lake, which just shows, again, that people in Salt Lake are not following it as closely. It's not as significant to them as it is here.
And there were 9, correct? 9 facts that you asked?
You're right, it's 9. Sorry.
And what were the 9 facts that?
Off the top of my head.
Do we have them in another
There's the slide there. You'd have to go to all of them. This is the recognition question. This is just, we can kind of skip through all this.
Dr. Dolan, let me ask you a question about
Sure.
the 8 media items.
Yes.
The state's expert, whose name escapes me at the moment,
Dr. Monson, Your Honor.
Dr. Monson, talks about the use of a red herring question to identify which respondents are just agreeing.
Acquiescing?
Yes, indeed. What is your view on whether any of that's baked into the recognition of the media items?
Absolutely. So actually, if you wouldn't mind jumping to that slide that kind of goes into that. Keep going. And I'll just keep going until you see the similar case that's similar to the bogus story that he used. Just keep going to the end of all this. But typically, you don't use bogus items. They're called bogus items in the change of venue world, and there's research on this. And the problem with bogus items is you have to create an item that's believable, right? If you create something that's so outlandish, it's obvious it's not a real item. But by using an item that's believable and close, it's not that people are acquiescing. It's that they've developed a cognitive schema about the case, and it's consistent with their strongly held beliefs. What you're supposed to use of what we did is we use items that have less reporting on it. They've only been mentioned a few times, once or twice or less, and you should see lower recognition rates for those items, and you do. We have an item that only has 11% recognition rate, which is our item. Rather than a bogus item, we use that. And I'll keep going, the example, one more kind of on the point of doing this is this. This is the bogus item that he used. A Washington County woman was arrested and charged with the kidnapping of a 9-year-old girl from Cedar City. Well, guess what? There's a bunch of real cases that are consistent with this within the time frame where they're doing the survey. And if you go to the next slide, these are all the stories. And jurors, if you look at the respondents in his open-ended about this case, keep going, they're not acquiescing. They're actually, this is a quote, this is an example of one person referring to this case. So it's not acquiescing because a desire to just say yes to be because of inclination. They're citing a real case that's similar to the items he created. And if you go to the next slide, there's a whole bunch of them that fit into that.
Did your survey use a bogus-ish, or, sorry, not a bogus item, but a
lower recognition.
lower recognition
Yes.
item? And what were the results there?
Jump all the way back. The two surveys, and there's huge differences. So why would people acquiesce in one and not the other, right? You would see that similarly, and you'd see yes consistently. You wouldn't see variance across the items. You would just see really high recognition rates across everything. So this one only has 43%. This one has, keep going. I think the actual item we used, it might not even be in here. Keep going with our listed, and you can see it. Until you see the list of all the 8 items. Those. Okay. So the last one. Kouri wanted to kill her husband so that she could start a new relationship with her boyfriend with as much money as possible. That only has a recognition rate of 12% in Summit County and 7% in Salt Lake.
Okay.
I don't know where we are now. Do you want to go back to some of the survey numbers?
Because this kind of goes to that too. Keep going until you hit this table. So this is how we check, again, internal validity. All right, there's predictions of what we expect to find from the social science literature. People who know more information, have more case knowledge, are more likely to have bias. That's what we expect to find. That's how you check for construct validity. That's how you check for internal validity. And that's exactly what we find in our survey. We're finding consistent, predictive relationships that are based on 30-plus years of social science research. That's some of the ways we test for this. And this is part of why we do it this way and why we use the established questions and measures that have been used for decades and validated. Okay. And
forgive me.
No.
And I acknowledge that your survey results may not either be this granular or this cumulative, but did you determine the area under some of these curves? Meaning, of the 400, what total percentage recognized between 0 and 2 or 3 facts? Does that make sense?
I'm sorry, I'm not. What do you mean? One more time for me.
Well, there's lots of small subgroups, right? And they're in each of these.
I got you. This is only for people who have read, seen, or heard about the case.
Okay.
Because the other people aren't asked any of these questions.
So, even among the people that have read, seen, or heard about the case, did you calculate what percentage of those recognize 3 facts or fewer?
Recognize which one?
3 facts total or fewer.
So you can see, so if a couple interesting things. One, you can see like 0 facts, only 29% say guilty, right? 71% have no.
Yeah, I know. I'm asking a slightly different question.
Go back a couple slides. It shows how many know this one here.
Thank you.
Yeah. I would have to look at the data itself to
So if I'm
reading
reading this correctly, among the 80% of Summit County respondents that have read, seen, or heard about the case, 35% 64% recognize 3 facts or less?
Yes, correct.
Okay. Okay, thank you.
Sure. And then, so if you jump ahead a little bit here, so this is just an example of one, and you're seeing, again, that how knowing this detail, this was widely reported, quite a few people know this fact, and it's correlated with perceptions of guilt and our fixed opinion question. So it's significantly related to that.
And do you have the percentage of people surveyed in Salt Lake who knew 0 to 3?
It should, in theory, be as well. This is just for Summit County.
Okay.
Okay, and then the next one, the Moscow Mule one, that's a big one. Very widely reported, very high recognition rates for this item. And you notice 77% who know it think she's guilty, and 57% reported that she'd have a difficult time changing their mind. This is one about buying fentanyl the weeks before. 64% know about that, and if you know it, very high guilt rate, 81%. And this kind of gets back to the voir dire problem of if you know this is a prejudicial item or the previous one, and they don't mention it in voir dire when you ask, what have you read, seen, or heard about the case? Well, there's a significant percentage that know it, but you can't ask this question, because if they don't, you're poisoning that juror. And that is the biggest unique thing about high-profile cases versus your regular case when you're doing jury selection.
And how is that going to be better with the Salt Lake County jury?
Well, that's true everywhere. If it's a case where there's pervasive media coverage and a lot of people know facts, you'd have to look and see what that recognition rate is, but it's lower.
It's lower? And we have that, don't we, in the survey?
It's in here.
It's there. Okay. All right, go ahead, Alex.
I think I understand these dynamics.
Yeah.
Was
Okay.
there anything else you wanted to put on the record initially here, Ms. Lewis?
Yes. Let's go. Just go ahead, and when we get there. Go ahead, Alex.
Do you want to talk about this, or?
Well, I want to talk about. I do. I want to talk about the survey that was conducted by the state, and as the judge said, the recognition level is similar. Mm-hmm. But why is the survey that you did more reliable and should be considered in terms of what we're going to actually see in the courtroom as compared to what they did?
Well, I think at a high level, I would ask, I'm not quite sure what the survey is trying to measure. So the survey I'm trying to measure is bias, prejudgment against a defendant, and whether a presumption of guilt is pervasive. There's no question in there about guilt or what their opinion is. What details, there's one question about details, which is just briefly described. So there's a number of issues there. The whole thing to me looks like it's a test. It's written, the cognitive effort to answer it. You've got, here's a list of 9 names, and then if you answer yes to each one, then there's a question about each name, and then here's a list of 6 random stories. Sorry. And then asking, how familiar you are with that. When we write surveys, one of the things you want to do is make it simple and easy to follow, because there's something called survey fatigue, and the more complex it is, the more likely you're to start getting bad data. So I don't think name is an appropriate identifier for case recognition. A lot of people don't recognize names. I mean, I remember I did the change of venue for the Pittsburgh synagogue shooting. Robert Bowers was the defendant. I would not assume if somebody doesn't know the name Robert Bowers in that area that they don't know the case. I don't think that's appropriate measure. Names are much harder to recall. And then just some of the I don't understand the definition of impartiality that he's using. Don't recognize the name versus not recognize the name. Does that make you impartial? It's not about recognition of a name. It's about, do they think that she's guilty? I've never seen a definition of impartiality in a case where it was just based off of if you say you know the case or don't know the case. That's not the criteria. The questionnaire design is another issue, I think, in terms of, like I said, the complexity of it. There's questions that I still don't understand what the question's asking. And then when you do an online survey, there's something called satisficing. And
I'm sorry, called
satisficing. And there's things you have to look at. So the way this was done was a text message to like 50-something thousand people. So you're getting it on a phone. You could be at a movie. You could be at dinner. Who knows where you are. And if you tap on it, you're given a survey, and you have to make sure people aren't quickly just burning through it fast to answer questions. You don't know how closely they're reading a question. You don't know if they understand the question, which is why we do telephone surveys, because you can read the question to the person. You control the pace. You can try to do soft refusal conversions to encourage them to take the survey. You can answer questions. You can ask probes. There's all these things you can do that you can't do in an online survey. One person was Googling stuff as they took the survey and literally copied and pasted something from a newspaper article into the open-ended question. You don't know if people are taking the survey with friends. I mean, you don't know if they're giving the link to someone else. I mean, there's all these things. Who takes online surveys when we're so used to spams and text messages? All of these issues. I don't know what the phone survey looked like because it was never provided to us. The other thing is, you always tell them there's no right or wrong answer, and you could always answer with no opinion or don't know. That was not done here, and it wasn't given as an option. One of the big things with yes or no questions, first, they're used all the time. Go look at a Pew Gallup. All of them use yes or no questions. They're not automatically affected by acquiescence. But you give a no opinion or don't know option, which reduces the pressure to answer yes. There's no option to use that here. So there's a host of things there. And again, there's 30 plus years of research on this. There's professional code from the American Society of Trial Consultants designed specifically to write change of venue surveys, which are based on APOR, American Association of Public Opinion Research, and research methodology that have been published. That's why we do it that way.
And the American Trial
Society of Trial Consultants.
They specifically in their code include the question about presumption of guilt.
Well, not a presumption of guilt, a measure of guilt.
A measure of guilt.
To measure guilt. That's the question, to identify if you can get a fair trial, not how many people know the case. They could know the case, and it could be nobody thinks she's guilty because the coverage was really favorable.
Right. And the
that's-
other one that is not in the state survey is checking specific facts of the case. That
Yes.
is one of the standards used in these type of
You
surveys.
measure case knowledge. Even his question, if you go next one, the case knowledge question, it's not even a measure. Well, this is the one when we talk about ambiguity and construct validity. Construct validity is, what are you trying to measure? So we're trying to measure bias. That's our construct validity. I don't know what this means. Thinking about your opinion of Kouri Richins or her case, how fully formed would you say your opinion is? I don't know anybody that understands what a completely unformed opinion is. And what happens is people interpret the question differently. Some people think it means uninformed. Some people might think it's not strong. And when people interpret the question differently, you have a problem with internal validity. If we all don't interpret the question the same way, it's not a reliable, valid measure.
So we need to use language that has a general understanding as opposed to something. We need to use language that people have a general understanding of what that means.
It's a basic standard of survey design, which is why the questions we use are piloted. We do cognitive interviews to make sure they understand them when we add new questions, and it's based on people doing this for 30 or 40 years. We don't just manufacture questions and then throw them into the wilderness. Yeah.
Okay.
And even when he asks what they know, he doesn't say, please tell me, first of all, please explain what you know. It's what have you read, seen, or heard, not explain. And the word briefly tells me, don't tell me everything you know. Be as brief and concise as possible, which is not what you want. You want a full explanation of everything. And then how certain would you say you are that your explanation is accurate? What does that mean? Does that mean that my explanation is accurate of what I know, or the explanation is accurate of the description, or are we asking if the media coverage is accurate? I don't know, but it can be interpreted different ways, and that's the problem.
Alex?
And then population of interest. It only looks at registered voters, and I don't know if this is significant because the list here is made up of the DMV list and registered voters, and only 63% of Utah eligible voter population is registered to vote. It's actually ranked as 45th in the country. So there's a big number of people who are not registered to vote but are eligible to serve as jurors because they have driver's license and in this county. There was no question about that. There was no question to remove felons, all the basic things that you typically include. So, yeah, that as well.
Go ahead, Alex. All right, I do want to talk about, and you have touched on a lot of this already, but is there anything else about voir dire and why that isn't going to solve the difficulties in this case that we haven't touched on
Yeah.
yet?
So one of the things that comes a lot when I do this is, well, why don't we just try to
Can I
pick
interject?
Sorry.
I need you to highlight the challenges of voir dire that are specific to Summit County that would not be present in Salt Lake County, given your survey results showing the substantial, though not as high, level of exposure to the case in Salt Lake County.
Yeah, so the problem that exists here in terms of if people have a lot of detail, like there are people in Salt Lake that know this case. The benefit, again, is they don't know as many case-specific details. They haven't followed it as closely, so fewer people are likely to know specific things that they know.
Can I ask a very practical
Yeah.
question? If you were advising the defense, would you advise them just strike everybody that recognizes the case?
Well, here or there?
Both.
Well, here's the problem in my mind. Let's say that's your gut reaction. So let's just get rid of everybody that knows about the case.
Yeah.
Here it's 80%.
Sure.
Let's say. Well, who are the 20% left? Well, what if your jury profile of when you're actually thinking about trying the case is like the best jurors for us are the most engaged in this community and they're most educated because they're most likely to stick to the jury instructions and most likely to hold the government to the beyond a reasonable doubt standard.
But with respect, you just pivoted to favorable jury, not fair and impartial jury.
Well, so if the idea is a fair jury are just people who are disengaged in the community, are not highly educated, don't follow the news, well, you got people that don't know about the case.
I think,
But
with respect, people that are relatively disengaged, overwhelmed with their daily activities, not engaged with the news, are fully capable of being fair and impartial jurors. So stick with the fair and impartial prong for me for a second.
okay, so I mean, if that's the premise, is it's okay to get rid of like highly educated jurors, or if that's your profile, then sure. One thing you can do is say, let's get rid of everybody who recognizes the case and see what's left. I mean, I've never seen the sides agree to that.
Why isn't that dynamic the same in Salt Lake County, though?
Well, in Salt Lake, there's fewer people that recognize the case, right?
Sure. So if you get rid of all of them, isn't the same dynamic of the people that recognize the case, in your view, are likely to be highly educated, highly engaged? I don't know, I'm spinning a hypothetical here based upon
There'll
what
be
you're
more
telling me.
people that are highly engaged, highly educated that don't know about the case
Where does that come out of your data?
because they haven't followed the cases closely. Like here over, what was it? The number of people in Summit County that are fascinated by this case, follow it closely, somewhat or very closely, are much lower than in
How
Salt Lake.
many facts indicate following closely versus not closely? What would be the break over there?
How many facts?
Yeah. How many media facts recognized
Oh, there's a
would
table.
indicate following it closely versus not?
You'd have to jump. There is a cross tab on there. Offhand.
Can we go back
Go
to
back
that?
to it.
Do we have any idea where it is? Go back, Alex. Is it this one?
Go back. Well, I mean, this would kind of tell you. This is a theory of 100 jurors walk into the courtroom. Let's see if this answers that.
I can do that math.
Yeah.
I need to understand your,
So you can see that second one. followed it somewhat or very closely, Summit County 40, Salt Lake only 11.
Okay, so let's stay there for a moment. Does it follow then that 60% of Summit County jurors do not follow the case somewhat or very closely?
Correct.
Okay.
I'm trying to find that. If you go back, there's a cross tab that shows the relationship of, so this is case facts, relationship, but go back one more. Keep going so you see it, a cross tab that shows. This one. Okay. So this kind of gets to whether they fought it somewhat or very closely, and you can see the guilt rate's quite high. And that's just a measure of what you'd expect of engagement. So if they followed it very closely, it's probably mediated through case-specific knowledge.
Right.
Which ties into guilt.
I'm trying to interpret the numbers at the bottom of this matrix. Does that mean that out of 400 respondents, 462 have followed it not too closely or not at all?
Well, it's not out of 400. This is out of the people that have read, seen, or heard about the case.
Okay. So bear with me.
And one thing, just because you passed it, but just mentioning that the rumors that have spread in this community as well that are unique here, that, yeah.
And so, back to Judge Mrazik's point, in Salt Lake County, the fact that someone has not heard as many factors or hasn't heard of the case, does that translate, as it does in Summit County, that those are just uninformed jurors? Or does it have to do with the fact that Salt Lake County has more of a news influx and it's a bigger county?
I always look
That
at...
might have been worded real
Yeah.
well, but I think you understand what I'm...
Well, I mean, let's take a step back. We started with Salt Lake County to see if recognition rate was lower because it's really close here and it's the largest county. Like, that's always the first step.
Correct.
That was the primary county I looked at, or only because it's big, it's 30 plus miles away, and recognition rate looked lower. If we're high numbers, we would have looked at a different county. We would have kept going further away. And
Let's talk about that just for one moment, because that comes up in the state's response. Why didn't you look at Washington County, for example?
Washington County? Well, we talked about that. So the plan was we had money in reserve to do 400 completes for a comparison survey. We didn't want to do 400 in one county, and then it turns out there's no difference, and we spent all that money. So the idea was to start with 200, stop, look at the data. If the data in Salt Lake looked bad and recognition rate was high, we would have done Washington County as the next one, and that way we're not burning through the county's money. When we looked at the 200, the recognition rate was much lower, so rather than spending another $11,000 to do more, we stopped.
And can you address also, do we need to be concerned about that we looked at 400 in Summit and only 200 in Salt Lake, and how that might affect the numbers?
How it affects, what do you mean?
How it affects the percentages. Is 200 enough to
margin of
make
error?
these?
Yeah.
Thank you, the margin of error.
It's 7, plus or minus 7 at 200, instead of plus or minus 5. That's it. And again, the point isn't precision I'm not trying to predict the outcome of the trial or the outcome of an election. I'm trying to weigh and assess if there's bias in the community. Reasonable likelihood, lower than the preponderance of evidence. So that's the question. Is there bias? Not precision and exact measurement. That's not what I'm really going for.
Okay. And what's your conclusion on whether or not there's bias in the community in Summit County?
Based off of the survey data and the nature of the media coverage, I think there's a reasonable likelihood that she can't get a fair trial here. I think the example, like I mentioned before, when we compare the open-ended, on average, I think people mentioned like 0.7 media items, details about the case, but they knew an average of about 4.3 additional items when we asked the closed-ended question. Only 10% mentioned the walk the dog letter, which is significantly related to prejudgment, but over 40% know about that. So those are the kind of things that come into play.
I just want to, I'm sorry, Doctor, I just want to clarify that. So when you asked the open-ended question, what do you know, 10% mentioned the walk the dog letter.
Yes.
But then when you went through and said, have you heard about the walk the dog letter, that jumped to 40.
Jumped over 40, yeah.
But that's only among the 80% that recognize the case
Yes.
writ large.
Right, but it shows you the problem, the pervasive problem of there's a group of people out there that know prejudicial, potentially inadmissible content. That's just one of the items, but you don't know who they are, and you can't say, well, Ray, did you know this? Because they could say no, and then you just told them. Or they could say yes, and then you just, again, confirm that people know more than they know. So what are you supposed to do as the in voir dire if you're the defense? How do you exercise cause challenges if you don't know if that person could truly be fair? You have to weigh what they know versus what they say. If you look at all the court decisions, that's important. It's a totality of the circumstances, and you just don't know what they know. And that is, again, I harp on this because I've done over a lot of these. I've worked on over 70 of these. That is the problem with these cases relative to every other normal jury selection we do. General attitudes are not predictive of behavior. Specific attitudes are. When we have well-developed attitudes, we look for information consistent with how we see the world. It's called confirmation bias. Information consistent with what I already know is given more weight. It's stored in long-term memory. It's easier to access. Information that's inconsistent is not stored into long-term memory. We make a cognitive effort to refute it. So all you're doing when you hear this evidence that's consistent with what I think about this case is confirming what I already know. You're triggering nodes in memory, which are all this stuff I saw in the media coverage, and it becomes activated, and new information is processed based on that. So in voir dire, when you ask, tell me everything you know, people will not remember everything because that's the way memory works. Just like movies we saw as kids, we don't remember everything, but when you watch it with your kid today, it's like unlocking a vault. You watch 10 minutes of it, and the whole story unfolds in front of you before you've seen it. That's how memory works, and that's how it works for jurors, too.
May I ask a question?
Yes.
You may.
Have you reviewed the questionnaire that went out? Not the responses, but the structure and form of it in this case?
I have not.
Okay. Thank you.
And I will say,
Well,
I might have looked at
That's okay. If the answer is no, that's fine.
Yeah, okay.
Okay. Thank you.
he actually did review a draft of the questionnaire,
Oh, okay.
the first draft of the
I
questionnaire.
did see that.
All right.
Is there anything else that we haven't covered that you think we need to talk about?
Not off the top of my head. The only thing I will say is one of the questions we ask are what rumors you've heard in the community and what you heard about the cause of his death. And that's where you see, again, small community, the spread of misinformation and speculation that about her, about whether she's a good mother and drugs and all these different things that aren't in the media. And you can see a strong belief in terms of the cause of death being what's widely reported in the media. So just, if you look at the opens, there's quite a lot there as well.
And you didn't see that in Salt Lake on the rumor question?
There's a much higher, I don't know, no opinion when you look at those opens there.
Okay. I don't think I have anything further.
Okay. Need a brief break, Mr. Bloodworth? I don't know how much time you have with Dr. Edelman.
Your Honor, I do not need a break. I don't know, 15 minutes?
Okay. You okay to keep going?
I have a diaper on, so I think I'm good.
All right. Very good. Mr. Bloodworth.
Thank you.
I hope that didn't get put on the record.
In fact, it went out to all the people that you worried about.
Good morning, Doctor. My name's Brett.
Good morning. How are you?
I'm well, thank you. How are you? As I read your affidavit, there's kind of two parts. One is styled a media analysis, and the other is styled telephone survey. Is that right?
Yeah, I think that's fair.
And then there's also, is it fair to say there's some interrelationship between the two?
I think it's a kind of like two-step, like, is the media coverage prejudicial, and then has it had an impact on the jury, I would say, on prospective jurors.
Okay, and is it fair to say that the media analysis is more subjective and the telephone survey is more objective?
It's a qualitative analysis, for sure. Yes.
Qualitative versus quantitative, then?
Correct.
Let's begin, please, with the media analysis portion.
Okay.
In your media analysis, you base it on a limited search of the park record. Is that accurately stated? It's page 10 of your affidavit. Do you have it there? I'm going to refer to it.
I try to be conservative with how I collect the coverage, so I looked at the park record. That's the local paper. I wasn't looking at things that don't have circulation in the community. So I would say it's an underestimate of the number of articles. I didn't look at the radio station stuff and things like that.
What sort is the park record circulation in Summit County?
Actually, can you?
This mic's not working for me apparently today. I'll lean into it.
Thank you.
What sort is the circulation of the park record in Summit County?
I'm not sure. I know in this survey, over 50% of people who read the paper mention that paper as one of the newspapers they read.
I take it then that you don't know the park records circulation in Summit County vis-a-vis ABC4's viewership in Summit County? Or KLS-TV's viewership in Summit County?
Is that the radio station or?
It's a TV station out of
TV
Salt Lake?
station, yeah. I was only looking at a conservative number of articles because I don't want to look at things, for example, in like the New York Times, because I don't know if people read the New York Times in Summit County. So it's a conservative estimate and a conservative approach to collecting the coverage and reviewing it to write the survey. So I'm not looking at blogs, I'm not looking at things like that. I'm looking specifically at the newspapers with circulation in the community.
And specifically only the park record?
Correct.
But you will acknowledge that people in Summit County read the New York Times?
Sure.
And they watch the 4 Salt Lake City local TV stations?
Yes. From what I understand, that's the only one here, right? You don't have a TV station that's just Summit County.
No.
Right.
Do you understand that the Summit County media market is the Salt Lake City media market?
Yes.
But you understand people in Summit County watch 48 Hours?
Sure.
Dateline?
Sure.
Good Morning America?
I'm assuming if people still watch TV these days.
Sure. And they read People magazine as well, don't they?
Yes.
Park record covered defense motions in this case, didn't it?
I'm sorry, defense motion?
The park record covered defense motions in this case.
I guess, sure.
Okay. On Q9 little I of your poll, or rather of your survey, I've been corrected on that, of your survey, you mentioned, you asked people what is their source of local news coverage, and they're supposed to give you a response. Can you take a look at that?
Let me see. Q9?
Q9 Romanet 2.
Let's see. That's only asking the source of Q9I,
Yes.
not their source of information.
Can you just clarify what it's
Yeah, so the reason I did that was back to the idea that the source of information gets stripped. People forget where they heard it. So I used this low recognition item. Have you read, seen, or heard if Kouri wanted to kill her husband so that she could start a new relationship? That was something the family spokesperson had said. And I wanted to see if they remembered that it was him as opposed to like in your, state's papers or something like that. I just wanted to know if they remembered the source of that particular comment.
And 23 people provided the source, is that right?
Yeah, I would have to go back and look. But
And of those 23, 3 referenced the park record?
3 out of 20, well, one, I don't have it in front of me, so was it 23 as opposed to 38?
Let's provide it for you.
Sure.
Ms. Lewis, while Mr. Bloodworth is looking for that, can I just confirm that this thumb drive contains the written version of Dr. Edelman's declaration survey results and supporting exhibits and appendices? Is that correct?
It does not include the PowerPoint, which I
Okay.
can send you. It only includes what I was unable to file attached to our motion because it was too large.
Okay.
So it's his declaration and the survey, but it is not the PowerPoint.
I understand that the PowerPoint, the tables in the PowerPoint, though, come from the survey results that are on the thumb drive.
Yes.
Okay, very good.
This is the one about the boyfriend. It wasn't it?
You have enough
It was
water up
referring
there?
to specific
Good, thank you.
Okay.
fact, I think. Okay.
Of course.
Thank you.
Sir, can you please again say what you're trying to measure there?
Well, what I wanted to measure was whether or not they remembered that some of these comments came from the state, or from this, I'm sorry, not you, from the family attorney who was speaking to the media, because I thought that was a significant source of bias
Okay, and then you asked them, what was the media source
of that item
of that item?
only. Now, it could be two things, because it was published in the newspaper, but the quote came from him.
Okay. And 23 people responded, and 3 of those 23 got their information from the park record, correct?
Yeah, which, that's possible. I mean, it was published in the park record.
And 3 got that information from the defendant, her mother, and her boyfriend?
Her mother, boyfriend, and Kouri. Yep. And that's, again, I don't know. It's possible that that's was some connection to that in an article as well. They might have referenced that. I don't know.
Your media analysis, you've already said it didn't include 48 Hours, Good Morning America, People Magazine. The defense filings, did it include the statements published in the media by the defendant, Ms. Richens' former counsel?
Yeah, there's articles, obviously, in the newspaper when she was the attorney. Is that what you're referencing? Or
Where, sir, do you cite those in your analysis?
cite them? I mean, they're part of the articles that we included in our, it should be an exhibit, the articles that I reviewed.
Where do you cite that in your where do you quote those articles in your affidavit? Where do you consider and analyze those articles in your affidavit?
I didn't quote them.
Where do you analyze them?
They're analyzing the qualitative review of, is the media coverage overly prejudicial or not?
But not analyzed in writing in your affidavit.
No.
You're familiar, of course, with the interviews that the defendant's family has given the media?
Yeah, that's part of, we didn't get to it, but that's part of the presentation I had, looking at some of the things that were positive things that she had put out. So there's negative media coverage, and then there's attempts to kind of balance it out. And you can see the reaction, one, how few people viewed that stuff, and the negative reaction, the comments people made when that was done. So it certainly didn't balance it. And you can look at the survey data and see the overwhelming opinion of her is negative, not positive.
Where in your written affidavit do you discuss that and analyze that?
It's in the survey report. What is your opinion of Kouri Richins, from very negative to very positive, and then the 3 words you'd use to describe her.
Let me ask a better question. Where in your affidavit do you address in writing the defendant's family's interviews?
I don't. There's a lot of articles and things I don't address when I do that at this section. I don't write out every single article and every single TV episode and every radio story and every podcast and every episode of court TV that references the case.
Well, more to the point, Doctor, you analyzed all media coverage, or much of the media coverage that's negative about.
I didn't say all. I told you I did a conservative analysis. I believe there's another
Doctor, if you'd wait for the rest of the question.
Sure.
But it's true that in your written affidavit, you did not analyze in writing any of the negative media, or rather any of the favorable media coverage.
Sure. Okay.
Mr. Bloodworth, we can move on.
Your Honor, I appreciate it. I will, because you directed me to, but I think everyone here is aware we're making a record not only for this court, but others as well.
Yeah, I think the bigger point is that as between Dr. Edelman and me, I have a better recollection of the media coverage en masse of this case.
I don't dispute that, Your Honor. Thank you. You address in your media analysis defense or state filings, our filings in this matter, but not defense filings. Is that accurate?
I'm sorry, I'm not following you. What do you mean? I address it in
your written affidavit?
I address the state's filing?
You address various states' filings in the case.
Oh, in terms of on the rec, yeah, absolutely.
But you don't address any defense filings, do you?
I didn't run across any defense filing that was balanced out what was in the state filing. I'm not quite sure. It seemed to me a lot of it was responding to what was out there on the state side.
So are you familiar that the defense has filed 3 times for sanctions against the state in this case?
To do what? I'm sorry.
Are you aware that the defense has filed 3 times against the state for sanctions in this case?
Sure. That's not...
Yes, sir.
Yes.
But you did not include that, and you did not find that?
No, I don't think that's significant.
Are you aware that the defense has moved to disqualify the state in this case?
Again, I don't think that's significant. People don't mention it when you ask what they've read, seen, or heard about the case. That's not significant, and it doesn't balance out case-specific details in terms of guilt.
We can keep moving.
Sir, can we turn briefly to the telephone survey?
Sure.
You mentioned earlier that the defense the state in its survey judged recognition on Kouri Richins' name.
One of the questions, yes.
What was the other question?
Embedded in 6 other stories about the Olympics and so on was a question about this case.
Wasn't the screening question there was 2 screening questions, right? 1, Kouri Richins' name, and then 2, a case involving a lady who allegedly murdered her husband and wrote a children's book about it.
Right,
Correct?
after, again, 9 names and then a blend of 6 stories that's in there.
So your survey was designed to assess case recognition, familiarity, and prejudicial media content and bias. Is that right?
I would say it's designed to measure the impact of pretrial publicity on prospective jurors, case recognition, and the impact on the presumption of innocence.
Sir, if on page 1 of your affidavit you wrote surveys was designed to assess case recognition, familiarity with prejudicial media content and bias, is that accurate?
I think that fits in what I just said, yes.
Am I right then that it was not designed to assess media content favorable to the defendant?
There's open-ended questions. What have you read, seen, or heard about the case? If somebody had favorable media coverage, they would have mentioned it if they remembered it. And there's research on this, and it shows that favorable pretrial publicity is not as impactful as negative pretrial publicity. Some of the most impactful pretrial publicity is negative character evidence.
But you'll agree there is some impact of favorable publicity. And you agree that it does have an offsetting factor to prejudicial publicity.
I'm sorry, say that again?
You'll agree that to some measure it offsets prejudicial.
No, it doesn't.
Never, ever, ever.
I don't think the standard is never, ever, ever. I don't think any answer to any question is never, ever, ever.
We can keep moving.
Okay.
You spent a significant amount of time addressing Mr. Skordas in your affidavit.
Yes.
Why didn't you address any of the defendant's various spokespeople?
I did. It's in the presentation, but we didn't go through it.
But it's not in your affidavit?
Correct.
You referenced the gag order in your affidavit. What is your understanding of the gag order?
From my experience, the gag order would be anything, you can't speak to the media.
Dr. Edelman, what is your understanding, if any, of the gag order in this case?
I'm assuming it's that you can't speak to the media.
Do you have a understanding of the gag order that was issued in this case?
Not at the moment. I'm sure I read about it at the time in the newspaper coverage.
You reference how the prosecution has not filed documents very often under seal.
Correct.
Do you have an understanding of the rules in this case when the prosecution can file documents under seal?
Mr. Bloodworth, we can keep going. I understand the dynamics at play there.
Sir, you write on the first page of your written affidavit, based on my analysis, it is my opinion that the Summit County jury pool has been exposed to prejudicial publicity, right?
Absolutely.
Would you agree that based on your results showing that 300 of 1,500 summons have not heard about the case, it's not the entire Summit County jury pool, right?
I don't know because there's new media coverage since they filled out that questionnaire. So, like I told you, I already watched one that was a 46-minute long.
I think, did I understand your answer earlier, that notwithstanding changes in the environment or additional coverage since you performed your survey,
Sure.
that would be your expectation?
Sure.
Okay.
So you'll agree the math extrapolates out to approximately 6,400 of 32,000 approximate Summit County jurors
Sure.
have not heard of the case.
Sure.
Okay. So I don't have anything further. Thank you.
Ms. Lewis, any additional questions for Dr. Edelman?
Just real briefly.
Do you need to reconnect that, Mr. Ramos?
I do. May I approach the witness?
Of course.
Your Honor, may I first retrieve?
Yeah, no problem.
Oh, give that back.
Once you're connected, Mr. Ramos will republish that.
Thank you, Judge.
I just want to review one of the
1
slides.
second. My apologies. I apologize for being slow. Alex, would you do me a favor? Unplug that for a moment. I apologize.
Let me know.
Brittany, it appears, yeah, plug it in. It's not a glitch-free system. We lost table 2.
No, we haven't been on all day on table one.
Oh, well, that's also important information.
We're pari passu now.
Okay. At the moment, I can't show that slide, but maybe you can just ask the question and see if we can go off my memory.
We skipped the slide earlier about the positive pretrial publicity in this case. Do you recall that slide?
Yes.
And what was it that you found in terms of positive publicity?
There were 2 things. One was a I think she did like an interview or something she sent from to a television station or news station. It was just a voiceover
A statement.
embedded in the story.
And that was the statement that was sent out between attorneys. Do you recall that?
Yes.
Okay. And what was the other?
I'm trying to remember what the other one was without seeing it.
Ms. Lewis, notwithstanding Mr. Bloodworth's cross-examination, I don't think there is a credible argument that the media coverage in this case has been complete, wholly accurate, or balanced. I think we can move on.
All right.
I mean, I've been on record with my concerns about it.
Correct. I don't know if I have
Didn't
any.
suddenly get religion.
Can I just make the point as to, just one more point on that, and I'll finish. How many, on the slide, and I don't know if you recall, how many people viewed that story compared to
It was
all
like
the other stories?
2,000, 2.1 or something like that.
Viewed the positive coverage? Yeah. All right. I don't think I have anything further, just one moment. I don't. I'm finished. Thank you.
Mr. Bloodworth, may we let Dr. Edelman step down?
Yes, sir.
Thank you for your time, sir. You're welcome to step down. Thank you. Counsel, may we take a restroom break before proceeding?
Yes.
Okay, we will take a 10-minute break back at 11:45. Thank you.
And to find its connection is some account. All right. Does your screen show the seal of the court?
The seal?
Yeah. Okay, good. Ms. Lewis, ready to go back on the record?
Yes, Your Honor.
Okay. We're back on the record in 231-500-139. Ms. Lewis, any other evidence that you wanted to put into the record on the motion to change venue?
No, Your Honor.
Okay. Mr. Bloodworth, is the state calling any witnesses or admitting any evidence? In addition to the stuff that's been filed?
No, Your Honor.
All right. Ms. Lewis, it's defendant's motion. You're entitled to the first and last word. Any argument that you want to
Yes.
put on the record?
Your Honor, a change of venue motion isn't a numbers game. That's not what this is about.
Right.
All right. That's why when we're looking here at the standard, is there a reasonable likelihood that she can get a fair trial in Summit County? And the survey that the defendant has submitted shows that there is not a reasonable likelihood that she can get a fair trial. The number of people in this county that are aware of the case, the number of people who know prejudicial details that have been out in the media, and the number of people who indicated rumors and speculation about the case that are not accurate in any sense, is extremely high compared to Salt Lake County.
Where would you say is the breakover point? This is something that I struggled with.
Well, I think we're talking about, when we're looking at the two counties, let me just say, we picked Salt Lake County because it's convenient. It's 28 miles. When we're talking about the gravity of what Ms. Richens is facing here, and to find a jury that does not have the knowledge of the case that Summit County has, taking that 28 miles is absolutely reasonable under the circumstances to avoid what potentially, and more than potentially, what, based on the numbers, not the numbers, but based on the survey and the response to the survey, shows that there's a reasonable likelihood, which is not a very high standard, that she can't get a fair trial here. Now, could we go to a different county? Yes. Could we go to Washington County? Maybe in Washington County, probably in Washington County, the recognition rate is going to be lower than Salt Lake County. Probably, and we could do that. But in determining where to hold a trial, it makes sense to look at the convenience of everybody who's involved. And I'm going to segue a little bit, and I don't think I need to spend time on this because I'm sure you know this. You asked us what we wanted to do, move the county to Salt Lake or bring Salt Lake jurors here. It doesn't really matter as far as the defense is concerned. It was not our position that we want to bring it here because we don't want her to be in Salt Lake County Jail during the trial. If she's been in Salt Lake County Jail during the trial, that's fine. But we have chosen all along to try and pick what is most convenient for everyone involved in this trial. We did that when we had a stipulation with the government or the state, and we still, that is why we're going to Salt. That's why we're looking at Salt Lake County. I don't think there's a magic number. There's not a magic number in terms of where we can have a fair trial. For example, in the Koberger case that Dr. Edelman mentioned, the recognition between Ada County, which is where Boise is, and I think it's Leda County, I don't know, where Moscow is, the recognition was almost identical in terms of the number of people who recognized the case or had heard about the case. What we're looking at is when we're looking at a large county, and Salt Lake County has 1.3 million people. So out of those people, 42% recognize the case. That means that we have a very large number of people in Salt Lake County that did not recognize the case, as opposed to here, where we have a population of 42,000 people, and 80% of them knew about the case, and out of those, 70% already believe she's guilty.
Let me engage with you on this for a minute. First, before I can get to the practicalities, I have to find that there's a reasonable likelihood that Ms. Richens would not get a fair trial in Summit County.
Yes.
Among the there are 4 factors I am required to consider, and then I'm also required to consider the totality of the circumstances.
Yes.
One of the factors is the effect, nature, and extent of pretrial publicity. So let's discuss the numbers under that factor. Yes, there are 1.2 million people in Salt Lake County, but only 1,500 of them were summoned, and only 1,400 actually completed the questionnaire. So what we're really talking about is 1,400 people, and what percentage of those 1,400 have been exposed to information about the case. Is it the exposure or the nature of their connection, following of the media attention?
Well, I don't think we can look at one without the other. Exposure in and of itself is not a disqualifier. That's why the state survey is problematic, because they say, well, you could bring in 1,500 people, and conservatively, you're going to find 165 who haven't heard about the case. That's not the point. We're not predicting, this isn't a political poll, we're not predicting the number of jurors who know nothing about the case. And you can have jurors who have heard of the case. Yes, I've heard of that. Yeah, I'm aware she's charged with murder. That is not the same as having a large percent of the population who knows not just that, but also knows those specific factors about the case.
Right, so if we drill down there, in Summit County, it was only 1,100 out of the 15 summoned who completed the questionnaire.
Okay.
And if I understand Dr. Edelman's testimony and results correctly, 50% of the people who recognized the case followed the case not too closely or not at all.
I don't think it was that high, but
I think if we add the
don't
two
have-
numbers together, it's exactly 50.1. 15%, 1/5, of the 79.8 that are recognize the case followed it not at all. So there's 131 out of the 880 that follow it not at all, about 440 of the 880 that follow it not too closely or not at all. Let's assume those numbers are roughly twice as large in Salt Lake County. In defendant's view, is that the signifier? Or is it other James factors that really matter here?
Well, I think it's all of them. That alone is not the signifier. No, it's not. I think what was important when we look at the other signifiers, particularly the standing of the victim in the community. In Salt Lake County, the familiarity with the Richens family was 3%.
Right. Up here, it's only 26, though.
26% said they were familiar with the family.
Right.
That's correct. But we also don't know here where our jury pool is going to come from. Now, those numbers looked at all of Summit County. All right? Recognition in Park City is probably lower than recognition in the eastern part of the county.
You'd expect.
You'd expect. And so when we bring in these people, we don't know at this point what the balance of that is going to be. So if we get a large group of jurors from Camas and Colville and Hennifer, then we have concerns. We don't need to worry about that in Salt Lake County. In Salt Lake County, there's not going to be a stronger recognition in parts of the county as compared to other parts of the county, if that makes sense. So you could bring in a jury here. We know 26% of the county overall, based on the survey, said they had familiarity with the Richens.
Well, 26% of the 80% that
Who knew
read,
about the
heard, or
case.
seen something
That's
about the
right.
case.
And we
Yeah.
may have people who don't know about the case that, in fact, we likely do have people that don't know about the case in Summit County that is familiar with the family, and we're going to get them in here, and those people are probably very likely, there's going to be people disqualified who may not have known about the case, but may know about the family and then have concerns about being on the jury. And those numbers, I mean, we're looking at a picture here. We're looking at a picture with the survey. But when we bring in the actual jurors, if we have a large percentage from the parts of the county where the Richens are well known, those numbers are going to be higher. So we're taking a risk by having a Summit County jury that we're not going to be able to seat a fair and impartial jury. There's a reasonable likelihood that we can't, because we don't know exactly where those numbers are going to shake out. But we know in Summit County, they're going to be there. In Salt Lake County, we can get jurors from the east side, we can get jurors from the west side, we can get jurors throughout the entire county, and we're not going to see, based on the numbers that we have right now, a huge difference, if any difference, for example, on that factor, the standing of the Richens in the community.
Do we have any evidence in the record that, but for the pretrial publicity, so put that aside, that Kouri and Eric Richens, or Eric's side of the family, is any more well-known in the county at large than, geez, we've done a lot of gnarly cases in this courtroom involving crimes against children, first-degree felony sexual assault cases, other murder cases.
I'm not entirely sure what you're getting at, but
I guess what I'm saying is, I'm not sure these people have a standing in the community that is as great as you suggest. Wouldn't the number be substantially higher than 26%?
the Richens family are the biggest landowners in the southeastern part of the county.
Well, one of the Summit County council members owes like an entire chunk of Echo Canyon, but like I'm not sure he's that well known outside from his former Summit County council members.
Well, we don't know.
I mean,
All we need,
here, we'll take it outside the Richens family. If an Osgothorpe was either a victim or not, I mean, there's a barn named after them on 224, but that doesn't mean that people know the family in a way that would disqualify them, right?
I don't know. We don't know the answer to
Okay,
that.
I appreciate, that was really my question, is do we know one way or the other? And yours,
We do know that the Richens have part of the library named after them. We do know that,
we know all Richens does.
well, there was no denial that it was this Richens family in the affidavit. I feel pretty confident if it were a different Richens family, that would have been included.
Okay, but I mean, geez, whatever. I understand your position, but more generally, I spent hours upon hours trying to figure out the through line through the change of venue cases and determine where district courts go wrong in denying a motion to change venue. And let me ask you about this. It seems that there needs to be an inflammatory plus factor that goes beyond adverse pretrial publicity. In James, it was the 45 days of community involvement searching for the missing infant. And during that time, that occurs immediately after the infant goes missing, the media coverage starts to turn on the defendant before he's even charged. Forgive me for a moment. A case that whose name I can't remember, the crime was alleged to have occurred in the courthouse. And so there the judge was concerned that we can't have potential jurors or impaneled jurors interacting with the crime scene every day of the trial. In Stubbs, for whatever reason, the judge only summoned 16 jurors for a venire, and 9 of them knew the family. So that is an outlier. But then we look at Kayer, Lafferty, Bishop. In Bishop, they had a survey. 71% of those people that, 80% of the respondents stated they believed the defendant to be guilty. No abuse of discretion. What do you see as the through line or the place where a district court commits a reversible error?
Well, let me first address. There are almost no cases that are using the reasonable likelihood standard because all of these cases, Bishop, Lafferty, they were interlocutory appeals. The standard had changed. By that time, that wasn't the standard anymore. And the court has to look at it from, was there actual prejudice at that point? James is the only case I came across.
Stubbs, right?
And no, Stubbs was post-conviction, and it said they applied the wrong standard.
Yeah, I think the Court of Appeals, though, says we're going to apply the James factors. And then the Supreme Court says, well, you did it wrong, but even though you did it wrong, your result was correct. But so if we look at the Court of Appeals decision in Stubbs, they applied the James factors afterwards. Your point is well taken.
Well, I think that's a major difference. We don't have a lot of data out there, but changes of venue occur constantly, and not all of them are, the O.J. Simpson case. They're not all, the level of prejudice that maybe was in the James case. There's nothing that says that the media coverage, the negative coverage, has to be at a certain level. It only has to be at a level that there's a reasonable likelihood that the defendant cannot get a fair trial. So I don't think there's a magic cutoff. There's not a point where it has to be this extreme where you don't get it. Where we have a number of factors out there in the media that some of them may not even be admissible once we get to trial, but they are in people's heads. We've got the walk the dog letter. We've got the financial motive. We have the paramour, which was something that was a term that was Greg Skordas put out there. And we can't ignore Mr. Skordas. We can't, because he is respected in the community. He is a spokesperson for KSL, which is the #1 watched news station in the entire state. And we have someone out there who's a commentator who now is out speaking against our client. Now, the difference between that and Salt Lake is in Salt Lake, people don't care as much. They're not paying as much attention.
Right.
And that's why Salt Lake is an appropriate place to have this. We're not saying that there has to be zero knowledge of the case. We're not saying that. What we're saying is is the jury so connected to the case? Is there such a community awareness or a community concern that they are paying attention to all of these negative factors? And here, it's clear from the survey that they are, that at least to a much larger degree than they are in Salt Lake County. You keep going back to the numbers. Well, there's still this many that haven't, this many that hasn't. That doesn't matter. We could always say that. There's always a number of people, a sufficient number that you could probably find 12 people who could be fair. That's not
24.
That's not what the standard is here. It's not. And under a reasonable likelihood standard, and the fact that it is so easy to avoid this issue in this case, so easy.
I can't consider that, though, until I make the first decision, right? Because if I make the first decision, it doesn't matter how easy or difficult it is, it's required.
That is correct. You're right. It's just, you're right, it's hard to separate those out because we are in a situation where this is an easy fix. And I
think it's one of the judges, it wasn't in James, was it in Stubbs, that the judge commented it would be super easy for me to just grant the motion.
To bring another jury into the county.
Yeah.
Yes, which we still think you can do, but it's neither here nor there because either way works. And I lost my train of thought.
I apologize for interrupting.
That's okay.
So I understand your position regarding standing in the community.
Okay.
I mean, the size and number is what it is.
It is what it is, and it's small.
Yeah. No, you're right.
It's a small community. And the gravity of the offense, all right, it's not a death penalty case, but other than that, it's
You'd acknowledge it doesn't include a child victim, no sexual violence, right? That seems to be notwithstanding the distinction you made on the reasonable likelihood standard, that seems to be a dividing line between cases. Adult victims.
In James it is, that's true. I don't think that's
Stubbs.
true in Stubbs, though, they really focused on other issues, but
Yeah, but I mean, 17-year-old high school student, rape victim.
I mean, I have a hard time addressing that because I do think a homicide is equally as prejudicial and the gravity of the offense as a 17-year-old rape victim. I don't know how you balance that factor out. I think one is as serious as the other.
Okay. That is a good faith position that the Utah Court of Appeals seems to differ on, but I agree. I understand.
I think, and honestly, let me just say, and of course this is just speculation, most of these really high publicity cases deal with children victims. That's very common.
Right.
That's what gets the high publicity. That's just not the situation here.
Right. And then we come to the fourth factor, the nature and extent of the publicity. Okay.
Which I think we've spent a lot of time talking about. It's permeated every single hearing in this courtroom.
Sure.
It's been out there since day one. I talk about in my motion the number of stories that came out the week she was arrested. Now, it's different than James because the community didn't know that this was being looked at as a murder until the arrest, so it makes sense that the publicity didn't start until her arrest. But if you look at the articles that came out within the first 3 to 5 days, I think is what I've listed, maybe it's the first 7 days, it was immediate, it was prejudicial, and it was all over the news. I think the fact that Dr. Edelman focused on a conservative focus on the Park record is meaningless because we know it's all over the news. We know that there's national media, but the national media, the point is 48 hours, or I think it was 48 hours, People magazine, yes, it's everywhere, but it's people in this community that are the most interested in this story. So those are the people that are the most focused.
Or a greater percentage of people in this county follow it closely.
I mean, yeah, it's the same thing. I mean, you can say it either way, but there's a much greater interest here than there is 30 miles from here. It's just the nature of the beast when you're dealing with this small of community. So I think the 4 factors in James are very, very clearly met here. Are they, is it a sensational story where a child was, found dead outside the courthouse. No, it's not that story, but it doesn't have to be that story for there to be a reasonable likelihood that she cannot get a fair trial here.
I understand your position.
I don't think I have anything else, but let me just double check. I think just in closing, and maybe I've said this, but there's not a perfect answer here. There's not a perfect jury pool, but that's true no matter in any case. We're not looking for a perfect jury pool. We're looking for a jury pool where she has a chance of having a fair trial. And in this county, there's a reasonable chance that that's just not going to happen.
Okay. I appreciate that. Mr. Bloodworth.
Your Honor, can we start as a matter of law? It's my understanding, and I've seen no writing that says otherwise, that the request for relief, the relief requested, is to bring a Salt Lake County jury into Summit County.
That was the flag in the sand made by Mr. Ramos following my frustration with the ambiguity in the motion filed by defense. I'm happy to give you a ruling about my authority to do that.
Your Honor, as the state has briefed, the state doesn't think you have the authority to do
You were
that.
quite clear about that in writing.
Okay.
Do you want to address that now?
Yes, sir, seems like a good place to start.
Anything you want to add on that?
I want to answer your questions to the extent you have them.
I understand the state's position. I'm just not persuaded by it as a matter of law for reasons that I can explain in a moment. Notwithstanding that the court may summon jurors from only one county, if the court determines a fair and impartial trial cannot be had in the county where the action is pending, and that's an if that is as yet unresolved, the court may summon a jury from another county. You're on record. You've created a record. I don't know if there's anything you want to add on that.
No, Your Honor, I don't have anything to add to the written record. I appreciate that you are citing a conflict in the jury and witness, in the language of the Jury and Witness Act.
Yeah, let's just do this now, recognizing that I'm not sure it's relevant yet. But should it become relevant, the court determines that it does have the authority to pull jurors from another county following the granting of a motion to change venue under Rule of Criminal Procedure 29. Granted, under Utah Code 78B 7-107 subsection 2, quote, prospective jurors shall be randomly selected from the county in which the trial will be held, end quote. That language was added in 2017 by State Bill 169. Senate Bill, 169. Senator Hilliard and Rick Schwirmer, the state court administrator at the time, spoke to the bill during committee hearings and stated this bill does not do anything substantive. It's just cleanup and technical changes, no policy changes. Then, Utah Rule of Criminal Procedure 29C1A states, if a party believes that a fair and impartial trial cannot be had in the court location or in the county where the action is pending, that party may move to have the trial of the case take place with a jury from another county or the case transferred to a court location in a county where a fair trial may be held. That rule was last amended by the Utah Supreme Court in 2018. That is after the language in Section 107, subsection 2 was added, and the provision regarding, quote, a jury from another county, end quote, was left in place by the Utah Supreme Court. This circumstance indicates that the Utah Supreme Court did not consider Rule 29C1A to be in conflict with Section 107, subsection 2. Moreover, in 2023, the legislature repealed 78B 3309, which was a statute providing that the court may on motion change the place of trial in the following cases, among other circumstances, when there is reason to believe that an impartial trial cannot be had in the county, city, or precinct designated in the complaint. Currently, 78B 3A 103 speaks to venue for civil actions, as stating that a court may transfer venue in accordance with Rule 42 of the Utah Rules of Civil Procedure. But the 2023 repeal of 78B 3309 left Utah Rule of Criminal Procedure 29 as the standard for transfer of venue in criminal actions. Considering the foregoing as a whole, the court rules that Utah Code 78B 107 subsection 2, Utah Rule of Criminal Procedure 29C, and the Utah Supreme Court's recent memorandum decision in this matter, upholding the court's determination that it can pull a jury from only one county, those three things do not conflict. Therefore, the court rules as a matter of law that notwithstanding that the court may summon jurors from only one county, if the court determines a fair and impartial trial cannot be had in the county where the action is pending, the court may summon a jury from another county. I'm more concerned with the if at the moment. Talk to me about that part.
Your Honor, the analysis is James. It's not whether or not there's publicity. I think everybody acknowledges to varying degrees that there is publicity, and well, I guess everybody acknowledges there's publicity, and everybody acknowledges to varying degrees the harm that that publicity may have upon a jury pool.
Brad? Microphone. It's really hard to hear from behind you.
I'm sorry. I don't know why it's quieter today. I can...
Would you
I'll
like
get a lapel.
Sure, yeah.
I
One
can
more.
hear you if you're right there in the mic.
But I'm leaning forward. Let me grab a lapel.
Okay. In all fairness, I think I'm kind of deaf in one ear, so that's part of it.
We have the technology.
Okay, is this better?
Wendy, does that work better?
Sorry, what?
Does the lapel mic work better?
It's fine.
Okay.
Good. Go ahead, Brad. I was sorry. I was listening.
Will you put it on your tie? Tricks of the trade. There you go.
Okay.
Please proceed.
So, Your Honor, it is all four of the James factors. It is not simply whether or not there's publicity and whether or not the publicity is on balance prejudicial. And the state acknowledges that, perhaps on balance it is prejudicial, but I think in fairness to, or, as the court evaluates Dr. Edelman's testimony, I think there is some offset. I think former defense counsel's presentation on 48 hours, the family interviews on 48 hours, the defendant's statements that got extraordinary media coverage nationally, I do think it does offset the otherwise predominantly prejudicial coverage. And I mentioned that here because, and we may discuss this later, I think the court should in some measure discount Dr. Edelman's testimony because he does bring to it a bias. I'm not saying it's a dishonest bias or an intellectually dishonest bias, but he is an advocate. And his testimony from the affidavit through to today only really analyzed half of the media coverage. And I think that bias is probably reflected in his polling as well. And the court saw it, I think, acutely today when the court would ask a question and Dr. Edelman would pivot to whatever he wanted to talk about in advocacy of the defendant. All right, but back to James, I guess. And the point that publicity is only part of the analysis. It is, to some part, a numbers game. Not exclusively a numbers game, of course not. But I think we kind of start with the numbers. And if you look at the defense's polling out of 1,100 Summit County jurors that returned the questionnaire, approximately 200 of them have not heard the case. And if you take that same measure with the state's polling data, it's approximately 400. So I think the court then needs to kind of look at whether or not, given somewhere between 200 and 400 summons jurors to fill 8 plus 4 seats, whether or not, through voir dire, we can select a fair and impartial jury.
Would you acknowledge, Mr. Bloodworth, that in some cases there seems to be an overriding concern that, notwithstanding the potential numbers game, there's some inflammatory plus factor, the formation of an angry mob at some point in the pretrial period, community involvement was heavily referenced in James. You would acknowledge that there are cases where it's not a numbers game, it's the inflammatory plus factor that determines the issue.
Your Honor, I do acknowledge that, and that does not exist here. This case had no media coverage until the defendant went on a book tour on local media.
Your Honor, I know it's argument, but he's stating things that aren't accurate. It had no coverage until she was arrested. That's when the media coverage started in this case.
I'll get to that in a moment. I understand your objection.
Okay.
Your Honor, I point to the ABC article that
Maybe we can just
cite.
acknowledge that we've considered lots of murder cases in this courtroom, probably many more than the Summit County electorate realizes, because for some reason they did not get covered while this one did.
Your Honor, I'm not being clear. I mean, prior to arrest, the death of Eric Richens was not covered. And it wasn't covered because there's not that plus factor.
Or it was covered minimally and factually.
In the sense of an obituary type of presentation, sure. But the community had no interest in Eric Richens' death until arrest. And that is an indicator that there isn't that plus factor that exists here. There wasn't a search, there wasn't a child, there wasn't something remarkably horrific that grabbed the community's attention.
Okay, I understand your position. Anything to add?
Your Honor, it looked like you had a question there a minute ago.
No. I mean, synthesizing the cases, the best I can do is to say pretrial publicity is a factor, but it's not the one that determines where the cases turn.
No, you're not. I think, no, it's not. I think you're accurate, Your Honor. I think the first James factor breaks in favor of the state. I think they were the defendant and Eric Richens had similar community standing. I think that...
Would you state, I mean, it seems that they had similar community standing to each other and to a bunch of other young parents who run small businesses in eastern Summit County.
Your Honor, right. In our paper, we use the word common standing there. And it really is. If you were to, objectively look at that family before Eric Richens' death, they were Summit County.
Right, okay.
Your Honor, as it relates to the nature and gravity of the offense, the gravity is undeniable. It's the defendant's facing life in prison, but the nature isn't particularly horrific compared with, well, James, but what's it? I'm blanking on Brinkley and the other cases.
Bishop, Lafferty.
Bishop,
Yeah.
all of them. And at bottom, I'm not sure that even the publicity, given all the prophylactic measures that the court has put in place, summoning 1,500, even if it's 1,100 post-questionnaire, employment of the questionnaire, which was developed with extensive input from the parties, and also the seating of alternates, and allowing the parties to question during voir dire. Voir dire works. And given the analysis under James, given the extensive prophylactic measures in the forthcoming voir dire, with the numbers available, we can seat 8+4 fair and impartial jurors.
Okay. I understand the state's position.
Thank you.
Ms. Lewis, you're entitled to the last word.
Your Honor, the court is going to consider the state's argument that Dr. Edelman is an advocate and not an expert and should be disregarded.
I'm not.
Okay. We were going to cover that, but we didn't based on the court's
No,
question.
I appreciate his admirably candid answers to my questions.
Okay. For the state to stand up here and say the offset of publicity takes care of the problem doesn't even pass the smile test.
Yeah, I don't think that's really their argument.
Okay. Well, I mean, they stated that. They said, oh, there's been positive publicity, so it all washes out. We know that's not the case. There has been a minuscule amount of positive publicity that nobody cited to in the summary when asked what they knew about the case. No one. No one said anything positive that they heard in the news or read in the paper.
You don't need to convince me of this. I've been concerned about the amount and nature of the media coverage writ large of this case since it caught court staff by surprise when the case was filed. I understand your concern.
And interestingly, when we talk about the gravity of the offense, and Dr. Edelman could probably speak to this, but a nature of case that typically gets a lot of publicity is when a woman is accused of killing a husband or a boyfriend. That is not unusual. That rises up to the level, in many ways, of when we have a child victim. Look at the Karen Reed case right now. Cases where women are accused of murder tend to have a higher rate of publicity than other murder cases, especially an attractive white woman, let's be honest.
Yeah.
It's different, and that's why this case probably has garnished the amount of publicity it has. And it's extreme. Publicity in this case has been extreme. I don't think anyone can stand up here and try and downplay that or deny it.
I agree with everything you said, but then it begs the question, that publicity does not stop at Parley's Summit. It's coming from the Salt Lake media market, national media, and new media. Why is a change to Salt Lake going to change anything?
Again, I think the survey makes that clear because people in Salt Lake County aren't as invested in the outcome of this case as they are here. They aren't following every detail of this case, whereas a huge percentage of people in this county are. And we don't know where those jurors are going to come from. We know that a huge percentage of the county as a whole is following the case. If we get a disproportionate number of jurors from the eastern part of the county, then that's going to be even worse. We don't need to worry about that in a different county, be it Salt Lake or really any other county in this state.
Or worry about it less. I mean, all the dynamics that are present in
Right.
Summit County are present in Salt Lake County, just not to the same percentage levels.
And that's all we need. It's a reasonable likelihood. It is a low standard for the court to determine that she can't get a fair trial in this county. It's low. So, yes, that is absolutely correct. But voir dire, and I'm segueing a little, voir dire is not going to solve the problem. Voir dire is not terribly useful in a high-profile case. And in Summit County, where we've got people who know about the case, 80% of people know about the case, and we are asking them to say, can you put that all aside and be fair? We know that jurors say yes. We know that.
Why would we do that at all? I guess what I'm saying is, why wouldn't we focus on the 200 that don't recognize it to start?
So we're going to strike every single person who said they've heard of the case.
Well, that's your decision, not mine. You're going to have to make those motions, but I imagine you're going to.
It actually is your decision, because we will
I'm
make
not
the
going to
motions.
strike people for cause sua sponte. I'm going to rely on counsel to identify those that need to be struck and make motions. You're going to have to do that. You're telling me you're not within your range of options in either county would be to choose to move to strike someone that recognizes the case or not, right?
All right, well, let's say we do that. According to their survey, we'll have about 165 people left in Summit County. In Salt Lake, we're still going to have a large jury pool if we were to strike every single person who said they knew about the case. And that,
Doesn't it bear noting that we're only going to do attorney-conducted voir dire, not only, of 180?
but how is that relevant in terms of who we're left with in the type of jurors that we have left?
Being absolutely transparent, right? 180 people are going to be questioned carefully by counsel over the course of 3 days, right? You
Yes.
with me? Okay. So, whether there are 1,000, 800, 600, or 400 people in either county that either don't know anything about the case or have read, seen, or heard about it, but don't follow it at all, does it matter which county they're coming from? As long as you have a sufficient headroom above the 180 to be sure you're actually going to get 180 that either haven't heard about it or heard about it but don't follow it at all? And I'm relying entirely on Dr. Edelman's survey for this question.
But again, you're turning it into just a numbers game, and that's not the standard.
Well, if it's not a numbers game in part, then the survey doesn't matter at all.
But based on your analysis, we would never have a change of venue granted, ever.
That's not true.
Why
If
is
there
that?
was an inflammatory plus factor, it wouldn't matter.
Wait, you say that? You lost me.
If there was an inflammatory plus factor in Summit County, it wouldn't matter at all, the numbers. If an angry mob had formed outside the jail when Kouri Richins was arrested, if the crime had occurred at the courthouse, if, for example, there had been, as in James, community involvement in a candlelight vigil for Eric Richens after his passing in a search for the cause of his death for 45 days after his passing, that'd be different.
The James factors don't say there has to be an inflammatory plus argument. It says we look at those factors, and those 4 factors apply here.
I guess what I'm trying to get at is, why do you think it's reasonably likely she's not going to get a fair trial if there's enough jurors to go around that don't know anything about the case? For example, in Stubbs, there weren't enough to go around. It was a big problem. In Iron County, these survey results would predict not enough to go around. Summit County's small, but it's not that small. This is what I'm struggling with.
But is that the standard? If you could-
Reasonable likelihood's the standard.
Oh, right. So that doesn't mean that you might be able to get a fair jury here. We might. That's true. We might. There's a reasonable likelihood that we can't. That's the standard.
But why do you say that? I guess this is, why do you see it's reasonably likely that she won't? Other than, is it a concern that the survey results do not accurately show the pervasiveness of the effect of the pretrial publicity? Because otherwise, we do a lot of these cases. We do a lot of murder cases involving normal people. We do a lot of sexual assault, first-degree felony cases involving normal people. We do cases involving gruesome photographs.
But how many murder cases have had over 150 news stories
This is what I'm asking you about.
in Summit County? I would say none that you've tried. Have you ever had a case with this many stories?
Wouldn't that
Negative
reduce the
publicity.
James factors just to the pretrial publicity, though?
It satisfies that factor. It doesn't reduce it to just that factor, but it satisfies that factor.
I appreciate that.
And I do think we meet all the other factors also.
Tell me why that is.
Well, nature and gravity of the offense.
Sure.
Clearly, we meet that one. It's a small community. We meet that one. The closest call is the standing of the victim. I don't, and I do think that's an issue here, and I've talked about it, I've explained it. I don't know, maybe I'm not making myself clear, but that is going to vary depending on where most of our jurors come from.
Correct.
So we know it's an issue here. We know it's a family that's well-known. We know that, but it is. I mean, when you look at, and you drive down the street and you see a library named after them, when they're the biggest landowner in the county, when they're extremely wealthy.
Is there evidence of that in the record? I mean, I got to go off the affidavits that were filed, right?
I don't know. I thought I got that from the record before we got in the case, but I'm not going to swear to that.
I mean, I can take judicial notice that there's a building called the Sheldon's Richens building that's a government building over at Kimball Junction, but Mr. Bloodworth.
Your Honor, there's no evidence of that in the record, and I don't think it's an accurate statement either.
Okay, I'm going to go with the first part, that I don't think there's an affidavit to that effect, but keep going.
Of jurors are going to know the family in Summit County. We know at least 26% in the county as a whole recognized the name.
Let me push you just a little bit, make sure we're working from the same numbers. 26% of the 80 that recognized the case. We don't know what percentage of the other 20 recognized it.
We don't, because they weren't asked.
Right.
But I'm going to guess it's not zero,
Probably along the lines of 26%.
probably.
Yeah.
At least. So, yeah, I think on that particular question, that 80% number is not as relevant as on some of the other questions, because people who know nothing about the case probably don't know anything about the walk the dog letter either, but people who know nothing about the case may very well know the Richens family or be connected to the Richens family. So that number, I think, if anything, is probably underrepresented, the 26%. I think it's big enough. It's big enough. It doesn't, not each of the four factors has to be the biggest ever. It doesn't have to be that every single person in the county knows them. It's the standing of the victim in the community is definitely something to be considered. This is not a nobody. This isn't a gang murder where nobody knows or nobody cares, sadly, who the victim might be. That's not the case we have here. We have a young man, a young, attractive man, a father whose family is very embedded in this community. And the fact of the matter is, Kouri Richins was only embedded in this community due to her marriage to him. Without him, her standard in this community drops significantly.
Didn't he grow up on the Wasatch Front and move here in 2012?
Who?
Eric.
He grew up in Davis County, I understand.
Okay.
But the family has had, my understanding is, and I don't know if this is in the record, but the hunting land here is well known.
All right.
And leased out for people to hunt on. And that actually, I do know, goes back to, and I think that's in the record, goes back to Eric Richens' grandfather. So the Richens family has been known in Summit County because his grandparents were here, even though he specifically did not grow up in Summit County. The family has been a long-standing founding member of this community.
Okay.
So I think it meets it. Is it a closer call than the other three factors? I admit it probably is, but it's enough. It's enough to meet the standard, the low standard of reasonable likelihood that she cannot get a fair trial. she can get a fair trial in Salt Lake County. We believe she can. We believe the numbers show that. We believe the survey shows that. We're dealing with a huge county comparatively. So, and in terms of voir dire, I just want to say, telling people to put it out of their heads, and when we get people in here who maybe are going to know more than you say, and you say, okay, we'll just get rid of all of them. I have no idea if that's going to be plausible, if that's going to work, what we're going to be left with. We're speculating. But when you tell someone who has a preconceived notion to just put it out of their head, let's be honest, it's just not realistic when there's a lot of publicity on a case. And there is a lot of publicity in this case. There's a lot of publicity in Summit County. There's a lot of publicity nationally. And again, I think it's really important that the national publicity does not have the same effect outside this county as it does in this county. So that's not a reason to say, oh, it's going to be the same anywhere else. It's just not true. It's like in the Kouri case. The knowledge of the case is just as high in Boise, but the connection to the case was not. And that was enough to change venue to Boise. This is very similar. The county sizes here are very similar. We're looking at a very similar situation. And again, the Supreme Court hasn't looked at very many cases on the reasonable likelihood standard. So we don't have a lot of law that we can rely on and point to. We really only have one case. And I don't think anything in the James case indicates it has to be this. It has to be this exact thing. That's not how case law works, and we know that. I believe we've met the standard. I think we've more than met the standard. And if we're going to ensure her a fair and reasonable trial, a fair jury, moving the trial out of Summit County is the only way to do that. And we would ask the court grant the motion to change venue.
Okay. We take a 5-minute break. Can't delay in a ruling here. Clock is ticking. I'll be back in 5 minutes. Thank you. Under Utah Rule of Criminal Procedure 29, C1A, if a party believes that a fair and impartial trial cannot be had in the court location or in the county where the action is pending, that party may move to have the trial of the case take place with a jury from another county, or the case transferred to a court location in a county where a fair trial may be held. A trial court must evaluate a pre-trial motion for change of venue based on demographic, geographic, and cultural evidence unrelated to the identity and potential for bias of an actual jury venire. A judge should grant the motion whenever he or she finds a reasonable likelihood that a fair trial cannot be had unless the motion is granted. And bearing in mind that the court must take the totality of circumstances into account, the factors to be considered include the standing of the victim and the accused in the community, the size of the community, the nature and gravity of the offense, and the nature and extent of publicity regarding the case. Here, regarding the standing and victim of the accused in the community, the court finds the declaration of Kouri Richins Benson, docket 945, to be credible and relevant to the standing of Eric Richens and the defendant in Summit County. In short, Eric and Kouri both grew up outside of Summit County. They moved here in 2012, and they subsequently began raising a family and running small businesses in Camas. Prior to Eric's death and the events alleged in this case, they had a standing in their community at Summit County that was roughly equal to each other and roughly similar or equal to Summit County at large, given that they occupied the statuses of young parents involved in small businesses in their respective communities. Regarding the size of the community, approximately 43 residents are in Summit County based on census.gov data and estimates as of July 1, 2024. Of those 43,000, 1,500 were summoned as jurors in this case, and of those 1,500, 1,100 completed questionnaires. As as noted, the court cannot and has not reviewed those questionnaires in any way prior to today. Notwithstanding its relatively small size, Summit County is not homogeneous. Based on this judge's experience serving in this county for the last 5+ years, there are material differences among county residents related to income, lifestyle, family structure, and religious and civic affiliations. And these differences express themselves, at least in part, between what locals refer to as the East Side, communities of Henneford, Colville, Oakley, Camas, and Francis on the one hand, and the population living in the Snyderville Basin and Park City on the other. With respect to the nature and gravity of the offense, defendant is charged with, among other crimes, 2 first-degree felonies, including 1 for aggravated murder involving pecuniary gain in administration of poison. These charges are very serious. While the state has declined to seek the death penalty, defendant nonetheless faces the risk of a life sentence. Notwithstanding the seriousness of the charges, this case does not involve some particularly inflammatory elements that are involved in other cases, such as the involvement of a child victim or sexual violence. And the fourth factor, the nature and extent of publicity. The court finds that there has been an extreme level of media attention on this case. And that coverage has been incomplete and therefore misleading. It has involved inaccurate summaries of evidence that may be admissible. It has involved discussion of evidence that the court has ruled is not admissible. It has included speculation by commentators who have no personal knowledge of the facts of this case. The nature and extent of the media coverage of this case is an indictment of those media outlets and our current media culture. But on the other hand, that coverage has been spread out over the 2 years during which this case has been pending, and there have been substantial periods of media quiescence between court hearings and between significant court filings. But even this level of media attention has not affected significant swaths of the community, according to defendant's community survey, which the court finds reliable. For example, 20% of Summit County residents have no familiarity with this case, or stated more precisely, Dr. Edelman's survey results would predict that 20% of Summit County residents have no familiarity with this case. That is, they have not read, seen, or heard about this case at the time that they were surveyed. Of the 80% of Summit County residents that are likely to have read, seen, or heard about the case, 30% of that 80 have not formed an opinion as to defendant's guilt. 50% of the people who recognize the case indicated that they follow the case not too closely or not at all. And 15% of those that indicated they recognized the case indicated that they followed the case not at all. Using the 1,100 potential jurors that have completed questionnaires in Summit County as a base to apply these percentages against, the court finds that approximately 220 have not read, seen, or heard about the case. Approximately 644 identified or would identify that they do not have a connection to the Richens family. Of the 878-ish that are likely to recognize the case, 270 are likely to respond that they have not formed an opinion about the defendant's guilt, and 131 of of the 878 that are likely to have read, seen, or heard about the case are likely to indicate that they have not followed the case at all in the public media. Given that attorney-conducted voir dire of 180 jurors is contemplated over the course of 3 days, these numbers, approximately 220 that are likely to not recognize the case at all, another 270 that have formed no opinion on top of that about Ms. Richens' guilt, another 131 that have read, seen, or heard about the case but don't follow it at all. They provide an ample pool from which the parties can exercise for cause and peremptory challenges regarding other factors and nonetheless clear 24 jurors for cause in an effort to identify 12 8-seated jurors plus 4 alternates that are undeniably fair and impartial. And while the numbers are not the only factor that must be considered by the court, they are a relevant factor. And they militate against a determination that the size of the community or the nature and the gravity of the offense or any concerns regarding the standing of the victim or accused in the community makes it reasonably likely that defendant will not get a fair trial. Moreover, and more broadly, as stated by the Utah Supreme Court in State v. Lafferty, pretrial publicity, even persuasive, adverse publicity, does not inevitably lead to an unfair trial. Here, considering the James factors as a whole, the court does not find a reasonable likelihood that a fair trial cannot be had unless defendant's motion to change venue is granted. Therefore, based on the totality of the circumstances discussed, the findings and conclusions made by the court on the record today, defendant's motion to change venue is respectfully denied. Now, defendant may choose to seek appellate review on an interlocutory basis of this ruling. And we'll talk about that in a second, Ms. Lewis. If they do, if she does, and if an appellate court determines that this court has abused its discretion in denying the motion to change venue and that the motion should be granted, the court rules as a matter of law for the reasons already stated on the record that the court has the authority to pull jurors from another county and that the proper result, if the motion to change venue were to be granted, would be to pull jurors from Salt Lake County for a host of practical reasons. First, it's just not that far away. It would take jurors from Murray, Holiday, or the zip code that I live in, barely more than 10 to 15 minutes than somebody from Colville to get to this courthouse. Second, in consultation with the Summit County Sheriff's Office regarding security concerns related to a high-profile trial, transporting a defendant back and forth from Summit County to Salt Lake County each day is not a good security plan. And third, with respect to housing Ms. Richens in ADC, there's no guarantee she would take her. They would take her. It's a Summit County case. She would likely have to be housed in Summit County. The witnesses are in Summit County. This is a Summit County case. It is not an abuse of this court's discretion to pull jurors from Salt Lake County for a Summit County case if defendant had shown or if an appellate court determines that defendant cannot find a reasonable likelihood or cannot, there's a reasonable likelihood that defendant cannot get a fair trial in Summit County. In short, if this case goes up on appeal, I want to make sure the parties get an opportunity to get guidance on that issue as well. Now, let me pause for a minute. I have a few procedural questions. Mr. Bloodworth, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Lewis, the parties will receive the 1,100 questionnaires probably by Wednesday, maybe Thursday morning. In the meantime, if defendant determines that she's going to seek an interlocutory appeal of this ruling, and if you're going to make a motion to continue the trial to allow that petition for interlocutory appeal to be considered and decided, sooner the better.
We'll do that now.
Go ahead.
We're making a motion to stay the proceedings and to continue the trial while we seek an interlocutory appeal.
And is it your intention, oh man, I got to ask you some very pointed questions here. Do you mind? And if you don't know the answers yet, that's fine. Have you discussed with Ms. Richens
Yes.
the certainty that she will remain in custody while that process plays out?
Well, we would move to reopen the matter of detention, but we've discussed with her that that is a possibility.
I am disinclined to reopen the matter of detention, so let's be very clear here. There are no material changes in circumstances since the last time I considered the issue that I'm aware of.
Change in the trial date.
Well, a change in the trial date is a material change in circumstance.
But
which
you're the
is-
one asking for it.
All right, well, we just want to make a record. We believe that is a material change in circumstance, that the trial date is going to now need to be moved. She's been in custody for almost 2 years, and there are certainly circumstances, there's a set of conditions under which she could be released and not be a flight risk and not be a danger to the community.
Let's assume that she's not going to be released and that I find that there has not been a material change in circumstances based upon defendant's request to continue the trial. Have you discussed with Ms. Richens the fact that that interlocutory appeal process may take years?
Only seeking an emergency.
Well, we'll take an emergency appeal. I don't think it will take years, but we know it will take a minimum of months.
Okay. I
And we
understand.
have discussed that with her, yes.
Okay.
Your Honor, to that point, can we get maybe a more complete speedy trial waiver?
Yeah.
Not waiving if they want to interpret our motion as a waiver, that's up to the court, but we're not waiving.
We're not waiving. If you want to interpret that by our motion, but we're not specifically waiving speedy trial.
I think the motion, Mr. Bloodworth, any speedy trial concerns are addressed at least during the period from this point forward by defendant's motion to continue. Any speedy trial concerns that have been baked in prior to today are what they are. I think that's true as a matter of law. Do you see it differently, sir?
May I confirm with you?
Why don't we all just take 5 minutes and make sure that you want to do this right now? Just forgive me, 5 minutes. Okay, I understand your position. We'll come back in 5 minutes.
Your Honor,
Yes.
before the break,
Any change in position? Okay, let's go one step at a time. The defendant is making a motion to continue the trial, correct?
Correct.
Any objection, Mr. Bloodworth?
Your Honor, I'm sorry. Can we restate that again?
Sure. Among the requests, but the only one we're discussing at this very moment, is defendant's motion to continue the trial so they may file a petition for interlocutory appeal. Any objection?
The state is prepared to go to trial. The state does not object.
Understood. Ms. Lewis, I heard you also say that you're moving to stay the case. I understand that to be a motion to stay pre-trial proceedings, jury selection trial. Is that correct?
That's correct.
Okay. Mr. Bloodworth, any objection?
Just a point of clarification, Your Honor, does that include a staying of all deadlines set by rule?
I think
For
it.
example, tomorrow would be exhibit witness disclosures.
That's what I understand, is that as of 1:30 p.m. on April 7, while the court would retain jurisdiction of the case, no no further pretrial proceedings would occur absent a specific request by a party.
Understand, Your Honor. It's prepared to go to trial, but it's not adjourned.
All right. Other than needing a written ruling, which I should be able to provide by, I'll say Wednesday morning, but it'll probably be earlier than that. We'll say Wednesday morning. Any other requests or clarification today, Ms. Lewis?
We'd also move to expand the gag order in this case to include that no parties are to release or issue written press releases.
Is that inconsistent? Certainly more briefly stated than the current order. Let me call that one up. That was referred to as a protection order. Is that correct, Mr. Bloodworth?
Yes, Your Honor, it is. Looking around to see if anybody both remembers the docket order.
No, I've got it. It's 204.
Your Honor, it just makes the rule in order of commands. Rule, what is it, 3.4, 3.6?
I'm looking at the wrong order. Forgive me. It does, but let's look at it together. Yeah, it's docket 68, protection order. All right, Ms. Lewis, the current order states, consistent with Rule 3.6 of the Utah Rules of Professional Conduct, that lawyers who have participated, who are now participating, or who will participate in the investigation or litigation of this case shall not intentionally, knowingly, or recklessly permit a witness, investigator, consultant, staff member, or other member of the lawyer's agency, firm, or team to make extrajudicial statements which, if made by the lawyer, would violate Rule .6. That rule prohibits extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. What is the clarification you're seeking?
Well, that didn't stop the press release going out. That was a violation of the rules of professional conduct.
You'll need to be more specific. My apologies.
The state's witnesses all testified truthfully, or at least the officers were all truthfully testifying. That went out in the press release. That violated that, but it didn't seem to help anything or change anything.
1 second. My apologies. Would you say the last sentence again?
That the press release stating that officers were all testifying truthfully violates the rules of professional conduct, yet that particular protective order did not protect the defendant in that case, in that situation.
Without the court making any finding about whether any press release to date has violated the order, is strict compliance with the order going forward sufficient?
Yes, I guess we'll address it if something comes up.
Okay.
And I obviously need to make the record.
I'm not sure you do.
Don't worry.
There's no motion. We can just move on. Okay.
Your Honor, and can I just state for the record that the defense was ready to proceed to trial. The point of this is not to delay the proceedings. It's not to give the defense additional time to prepare. We were prepared to go forward. The point of this motion, for the record, is only because we believe that she cannot receive a fair and impartial trial in Summit County.
I find that representation to be genuine.
Thank you.
Okay, Ms. Lewis, anything else on the record?
No, Your Honor.
Mr. Bloodworth,
I appreciate that the court just
we're moving it along here.
shut down the discussion.
Yeah.
But defense counsel just alleged an ethical violation by the state.
Yeah, we're
We
going to
already alleged
stop,
that. That wasn't a new allegation.
folks.
Your Honor, OPC's ruled on it.
Please stop. I'm not joking. Have a seat. Ms. Lewis, anything else on the record?
No, Your Honor.
Other than what you were about to say, Mr. Bloodworth, anything else on the record?
No, Your Honor.
All right. The motion to continue the trial is granted as unopposed. Defendant's motion to stay pre-trial proceedings, in this case from this point forward, is granted as unopposed. The court will issue a written ruling that incorporates its ruling from the bench regarding the motion to change venue so that there are no impediments to defendant's ability to seek appellate review on the motion to change venue. Ms. Richens, I wish you the best of luck. The court is in recess. Mr. Romo, should we talk about the forgiveness?
All right. Judge Dandy getting all father-like there at the end. Please stop. I'm not joking. Don't make me turn this court around. Don't make me stop this court and have me come back there. All right. So basically, to sum it up, Kouri Richins wanted the change of venue. Judge denied it. She's appealing it. Judge says, are you sure about that? That could take like years. And they're filing an emergency, what's it called? Emergency appeal. They think it may take months. So again, Kouri, you asked for this. It's kind of hard to feel sorry for you. You're the one that asked for this. All right, so I'm just going to kind of read. I pulled together some news clippings, and then I have some stuff as well. So let's see. It paid attention to case awareness surveys conducted in both Summit and Salt Lake counties. One survey was conducted on behalf of the state prosecutor, while the second survey was commissioned by attorneys representing Richens. Now, the guy who did it, Dr. Brian Edelman, he also did Kohlberger. I guess he did something in 2024, a survey for Kohlberger as well. Yeah, Zach. Good. Zach, I'm testing you. I'm testing the chat. What guitar is in the background today? So Zach wins. Zach wins the what guitar is Squeegee have in the background today. So the goal of both surveys was to determine whether or not media coverage of a case could provide potential jurors to come in with preconceived biases about the accused, potentially denying them the constitutional right to trial by an impartial jury. Right? So Edelman said there were 400 people that responded. I think 1,100 went out, and it's dial. They basically call. It's a random digit dial survey, right? So 79.8% said they have read, seen, or heard about the case, and 22.2% of them said they have not. 30% of those said they have no opinion, right? So let's see. The defense filed an expert affidavit as a supplement, so that's Dr. Brian Edelman. So Edelman served as an expert witness in a number of high-profile cases, and including Brian Kohlberger. So he conducted a similar survey on behalf of Kohlberger's defense in 2024. Now, Edelman said people who know information, have case knowledge, are more likely to have bias. That's exactly what we find in our survey. We're finding consistent, predictive relationships based on 35 plus years of social science research. Let's see. Now, Judge Mrazik, Judge Mrazik, he shared concerns over the media coverage, but said that they didn't meet all the legal standards required to move proceedings or call jurors from a different county in Utah. defense attorneys had to prove there was a reasonable likelihood a fair trial couldn't be had with a local jury, and they had to show more than just substantial or prejudicial pretrial media coverage, right? So you can't just say, oh, there's all this pretrial coverage, I want to have change of venue. But now Judge, he agreed with the defense that the charges were serious, but he noted the case doesn't involve inflammatory factors that led to moving Utah cases in the past, like a child victim, like something that included like a child. I guess, yeah, people know this trial, but they're like, yeah, whatever, it's Kouri Richins, whatever. You know, I don't have an opinion, whereas if it's like Lori Vallow, oh my God, she did this to these children, you know, to the gallows with her. So people don't have as much of a visceral reaction with Kouri as they do with Lori. Kouri and Lori. So Judge Mrazik went on to say, when it comes to the size of Summit County, there's enough potential jurors. They've neither heard of the case or they've not formed an opinion about it. Finally, he said that Kouri and Eric, who is the gentleman who has passed, who was killed, they have a similar standing in the community. So one's not higher than the other. One's not. It's not like he's a political figure, a sports figure, an actor, you know, celebrity, if you will. He cited logistical hurdles that would come from transporting Kouri from Salt Lake City all the way over, or having jurors commute from Salt Lake City to Summit County. I don't know the distance. I suppose we could look that up at some point, which we probably will. But for now, the judge respectively denied. And he said, you can appeal it now. Defense immediately went to do an interlocutory appeal. And the judge is like, are you sure about this? Because this could take years. And they're like, oh, no, we'll do it. It's going to take months. And of course, Kouri got emotional about that. He was disinclined to reopen the detention because they wanted to rethink her being out on bond, and she's not. She's in jail. She's been in there for 2 years. So they wanted to rethink that while this appeal process goes on. He's like, yep, nope, not going to do that. Let's see. Defense wanted to expand the gag order. Then defense finally said, hey, we're prepared to go forward. This doesn't mean we want to delay. The sole purpose of this was to get a fair trial. And then at the end, Bloodworth stood up and he was talking about something. I didn't quite catch exactly what he was talking about, but the judge was like, stop. He's like, please stop. I'm not joking. So, that was Kouri Richins' pretrial from April 7th. Is she LDS? I don't think so. Zach's like, sit your ass down. Yeah, he basically did. Northwest, Kouri is a maiden family name. That's why it's spelled O-U-R-I. Only fan. It was her own walk book interview and walk the dog letter, which wrote to her infamy. Excuse me. And Brad asks, is she LDS? I haven't heard that yet. So I do not know that. Ken, thank you. I was going to Google it. Ken, thank you so much. Interlocutory appeal is when a party appeals a trial judge's ruling while the case is otherwise proceeding, or can only do it with certain things like losing a change of venue motion. So to me, it sounds like interlocutory. It's like, somehow it's interlocking. It's bridging a gap or something like that. At least that's the way I'm kind of taking it. But Salt Lake County is right next to the Summit, so judge is correct. It is fun to say interlocutory. Curvy will have to go back and watch Monica's reaction. You heard the verdict while parked, but didn't really get to see her reaction too much. Glad the jury got it right. And listen to Mona. Mona called in afterwards, Curvy, so check her phone call out. Widespread Kouri used to be LDS. Well, let's look it up. Is Kouri Richins? LDS. Mormon mom promoted bereavement book a month before, apparently. Eric was a member of the Church of Jesus Christ of Latter-day Saints. This is from his obituary. Being born into the Richens legacy shaped Eric's formative years, resulting in a lifetime of hard work, dedication, and fierce loyalty. So he has 3 sons, 9, 7, and 5. Remember earlier we were trying to figure, wow, I'm really blown out. Earlier we were trying to figure out how old his children were. Now this was when he passed away, which was 2022. So 5, 7, and 9. So they're 7, 9, and 11 right now. Excuse me. He was a member of Church of Jesus Christ of Latter-day Saints. He served a 2-year mission in Mexico City where he learned to speak Spanish fluently. He received a bachelor's degree with international studies with a minor in Spanish. So I guess they were. I did not know that. Services will be held at Hennifer LDS Chapel. That was March 10th, 2022. So there you go. I don't know if she is right now. I have no idea if she is right now, but he was. Once LDS, always LDS until it, and if you are excommunicated. Zach says, I have more info on Mormons now. The word of wisdom only prohibits hot drinks like tea and coffee. Later on, elders clarified that as caffeinated drinks. Oh, here we go. I just finished reading that. Eric was an LDS missionary. Kouri is she's just LDS. Northwest member, but were they practicing lots of drinking? That's true, right? He was drinking Moscow mules and Jello shots. Sherry M., your chair looks more comfortable than the judge in the Richens case. Thank you, Sherry. This was specifically purchased by several of our mods and several of our chatters, led by Therapist You Know. Pammy was involved with that. Hellcat was involved with that. Krista Limited Edition. So, yes, the captain's chair. My back is so much better. You guys have no idea. Capri Law, Moscow Mule drinking isn't typical for LDS, but no judgment from me. Okay. And Joe Schmo, here's a chance for me to shout out Joe Schmo. So if you guys don't know, Joe and I have been Joe's at Lori Daybell's trial, right? He's there. He has his own channel, Joe Schmo 88. So go check him out. Let me pull this up again. So he's there, right? He's there, and we've been we're covering Lori as well, as you guys know. So we do recaps every night, right? So last night, Joe told us that because court is off today, he's got a couple things going on. One of them is this. I will drop in the chat. If you guys remember Lori's first trial in Idaho, Joe is going to have a conversation with Tom Evans, who is juror number 18 at Lori's trial in Idaho. So that's Friday. I'm sorry, that's Joe. I should have put the time. Hold on, I got that. So that's going to be April 13th at 5 o'clock. All right, so April 13th, 5 o'clock. So Joe, let's see, April 13th. April 13th at 5. And that's Eastern. All right, let me do this again. So guys, definitely go check this out. We will be there, meaning I will definitely watch this. Okay, April 13th, which is Sunday. So definitely go check that out. So if you guys are at all interested in Lori Daybell, her first trial, Tom Evans, was juror number 18. So definitely go check that out. Yeah, I agree, Zach. This is great. Freudian slip and fall over. I love that. That's so cool. I don't know why I'm so like right now. Therapist asks Capri Law, do you have an opinion you'd like to share? Let's see. Hellcat. Aw, deserve it as long as I sit there for us. Thank you. Thank you, Hellcat. Appreciate that. Yes, that's Sunday at 5. Much better than 9. Yes, thank you. That's 5 Eastern, and then I can't do math right now. 2 o'clock Pacific. Yeah, no problem, Joe. Guys, definitely go check him out. It's going to be a great show. We will be watching. We will be there. All right. So next up we have Shanna Gardner, which is out of Jacksonville, Florida. And we will be covering that trial as well. And that starts in 6 minutes. So, Jags girl is already there. Can't wait. It's local. All right. So we have a redirect on. We are going to be popping over there. Busy day, right? Busy day for trial watching. Monica was live. Kouri was the 7th. And I think this one was from the 7th as well. I think this was from the 7th as well, if I'm not mistaken. So busy week, right? Busy week. I'm sure a redirect is on. I know Aaron did. But let me just go and make sure that live reactions, all that good stuff is off. Okay, cool. All right, guys, I'm going to end this, and I will see you over at Shanna Gardner, because who doesn't love a judge named London Kite? London Mahogany Kite. She's like one of my new favorite judges. So, a therapist, I hope we get an episode that recaps Olive Gardner. Yeah, there's been a lot. So anyway, thank you, Aaron. Thank you to our mod squad. Thank you to chat. You guys are great. It's been a great day so far. It's Super Ball's birthday. Come join us for more partying. Super Ball. She's all drunk on tuna. she's all hopped up on tuna. She's sleeping off her tuna buzz from this morning. Yeah, join us over at Shanna Gardner. We're going to go over there. So thank you guys for watching, and we'll see you in 4 minutes. Until then, bye.